Take liberty.
Lordship, I may pardon to.
I'll stop senior advocates making mention.
We are conscious of that.
I said after 19th of January, I'll not allow you.
It should be with prospective operation.
Lordship, may I please your Lordship, I am virtual.
So it can be muted at certain cases.
No, so that others are also informed that they will not be allowed. Let it be on YouTube.
Lordship, I may pardon to mention, Lordship. Lordship, I may pardon to mention, I am in virtual, Lordship.
Acha.
Lordship, I may pardon to mention. One matter pertaining to this formula.
All the sections will come.
Lordship, I may pardon to mention.
Pardon to mention, my lord, today's supplementary list item number 40. My lord, I was informed by London Advocate General that he is very oddly placed today and is having inconvenience.
My lord, I am already here. My lord, the matter was agreed to be fixed today. I have already arrived to appear in the matter physically. He can't take us by surprise at the last minute. This is the 5th time which has happened. So I will commence my argument, and this is very unfair to the court, my lord. 3 times I have come before also.
We will hear you.
Very well. Great.
Rightly demands you should have informed him because he's come all this way. You can't take
We will
him
hear
by
him.
surprise.
Lordship, I may pardon to mention one matter pertaining to this formulation of the policy on Chilka, Lordship. This
All right.
matter has since long it is not in the list. This is the rubble pitch number 7469 by
Give your slip.
2007.
Please give your slip.
Lordship, I am giving the physical slip, Lordship. I am handing to the learned court master, Lordship.
Item 44. I have already received PwC post. Item 44, ma'am. The supplementary. I have already received PwC file counter with the
You have received what? PwC.
PwC. Already received.
Have you taken consent of the learned counsel?
I will
Petitioner?
inform them. I will inform them.
Will inform, will not do. He may come
Let
and
the matter
object.
be taken up.
We grant time for different press.
Supplemental list matters under the heading for orders.
Just click the.
Item number 20.
Delay of only there. Regarding the regulation, multiple steps.
Item number 20.
20. He's
Lordship, in respect of similar sets of facts, the coordinate bench of this Honorable Court has rejected on the ground of laches and delay, relying upon a judgment that is the state of Orissa, and it has been confirmed by the Honorable Apex Court. Lordship, I can say
So what has been confirmed? The law or the condonation?
there is a delay, Lordship, 323 days in respect of this case. But that was it is 184 days, but that was in that is 323 days. Only
Maybe.
the length of that period is the difference, but sufficient cause so far as it is concerned.
Maybe.
This settle your Lordship.
Have you filed any objection?
Yes, yes, fine and
I
object.
have filed my objection, Lordship, and copy, sir.
Condoning the delay. Let us see the order.
20.
Order is 16, madam. Order 7. Court, after going through the magistrate available records, find that the claim of the petition for regularization is covered by the resolution issued by GA Department on 17/9/2014.
We are condoning the delay.
1/2014. Similarly, issue has also been dealt with by this court in the case of.
All right. They are condoning the delay. And
Heard Mr. K.C. Kaur, learned government advocate, and Mr. Budhiram Das, learned counsel, appearing on behalf of the respondent. This IA has been filed for condoning the delay of 186 days and filing the writ appeal. Satisfied that sufficient cause has not been shown for condoning the delay, but considering, but in the interest of justice, we are inclined to condone the delay, but subject to payment of cost of rupees 5,000 to the respondent within a period of 2 weeks. All right. The IA is accordingly allowed, the delay in filing the writ appeal is condoned. The IA is accordingly allowed and disposed of. Copy of the appeal memo, has it been served? Copy of the appeal memo may be served on learned counsel for the respondent by 23/12/2024. List the case for fresh admission on 9/1/2025.
Item number 21.
Madam, there has been a delay of 138 days. This is pertaining to that Sharachandra Parida case. Now your lordship have posted those matters to 22nd of January.
All right.
Right.
So same order. You should notice on the question of condonation of delay, returnable within 4 weeks, requisites for which shall be filed within a week. This is the case on
22nd
same day, na?
January.
22nd 01/2025. Yes.
Item 22.
Item 22, my lord, there has been delay of 196 days.
Notice has been issued. Probably it was listed yesterday. He had not appeared.
Yes, ma'am. Yes. Today also is not there.
This IA has been filed for condonation of delay of
196 days.
195 days in filing the writ appeal. Notice had been issued to the respondent, and Mr. Tushar Kanta Naik and associates have appeared on behalf of the respondent. Full stop. The matter was listed. Order ta color nahi bate. It was listed yesterday, right?
Yes.
The matter was listed yesterday. As there was no appearance on behalf of the respondent, it was adjourned to today. Today, when the matter is called, no counsel appears on behalf of the respondent. Full stop. After hearing Mr. Bimbisar Das, learned additional government advocate, and 3039, not 3038. After and considering the grounds taken in the IA for explaining the delay, we are not satisfied that sufficient cause has been shown, but in the interest of justice, we are inclined to condone the delay in filing the appeal, subject to payment of cost of rupees 5,000 to the respondent within a period of 2 weeks.
2 weeks.
List the case on 2 weeks.
Yes.
List the case on 9/1/2025. List the case of fresh admission on 9/1/2025. Yes.
Item number 23.
This we had dismissed for default, but he came and mentioned, so we had adjourned to today. Today also there is no appearance. This appeal, I think, is not mentionable. In prayer of the learned counsel for the appellant, the matter had been adjourned to today, full stop. But there is no appearance on behalf of the appellant when the matter is called, full stop. List the case on 9/1/2000 in the interest of justice. List the case. List the case on 9/1/2025. Yes.
Item 24.
24, my lord, there has been a delay of 217 days. 219 days. Pertaining to Malayananda Sethi case, which has been posted to 22nd of January.
219 days.
Yes.
19 days they have taken off.
As per your calculation or the stamp reporter?
They have only mentioned in the IA.
Stamp reporter says 217, so the calculation is wrong. Okay. No, Malayananda Sethi, but what is your objection to the order?
The order.
Yes, impugn order.
Yes.
Yes.
What we say, my lord, Malayananda Sethi case, no issue has been decided. But rather it has been left open as to whether from the date of application or from the date of consideration it will be taken. That has not been decided, left open. So relying on that, any judgment. $217 days.
Yes. What is the issue?
Issue is Malayananda Sethi. Nothing has been decided in that judgment. Your lordship knows that.
Yes, we are condoning.
But so far as the delay is concerned, my lord,
Yes.
217 days, 219 has been mentioned by them in their IA for condemnation.
We have condoned to 1,000 delay of 1,000 days.
My lord, my only submission is that what they have cited, the reason for such delay is that procedural.
Yes, we accept that the reason has not been explained. There is no justifiable reason for condonation or delay. Therefore, we are imposing cost. We will impose cost, we will condone delay, and then we will consider your case on merit.
Same order. We are taking the same order, only learned counsel, Mr. Vishal Vaibhav. All right.
Item number 25.
Copy of the appeal memo
Yes, sir.
by
By 2 days.
Monday. By Monday. All right. Copy of the appeal memo we served on Mr. Vishal Vaibhav, learned counsel appearing on behalf of the respondent. This is the case on 9/1/2025 for fresh admission.
Item number 25.
Subject to.
Cost of rupees 5,000 to be paid within 2 weeks. Yes.
Item 25.
Item 25 on 12, when receipt is applied for certified copy, but they have not received it. 1 more week time may be granted for filing the certified copy.
List the case on 2/1/2025 as prayed for.
Item number 26.
26, 494 days delay. But the question of law has to be decided by law. Conviction in a vigilance case. It has been challenged, but no stay has been granted. He is asking for pension. He cannot be unless and until it is.
Yes. IA for condemnation of delay. So you shall notice for the 4 weeks, 6 weeks, list on 9/1. 9/1/2025. Sorry. Check the hour.
6 February.
Okay. Sorry. 6/2/2025. Yes.
Item 27.
Your posted.
That's the
6/2. The requisites please file within 1 week. Yes.
Item 27.
That the delay of 261 days, I had taken time to file an objection. My objection is already ready, but could not be sworn in. I pray that I will file it by Friday. My lord, my list is next week.
Learned senior counsel submits that the objection to the application for condemnation of delay shall be filed in course of the day.
And tomorrow, by tomorrow.
Will be filed by tomorrow. Full stop. If the same is filed, the registry shall incorporate the same in the digital record. This is the case for orders on 23/12/2024. Yes.
Item 28.
28, my lord, there has been a delay of 627 days. Whether work charge employee can be brought over to the regular establishment at least for a single day by creating a supernumerary post for the purpose of regularization. That is the
It asks to create a post of junior steno and abolish the post of senior steno.
create a post of senior.
Just check. I think direction for abolition of a post and creation of
Yes.
another.
Permission of another post to create.
Which page is the order?
The order, my lord, it starts from page 26. 25, my lord. It starts from 25. Relevant portion you also will find. Para 21. It will also contain that relying on service and many other restrictions.
Oh, you retired on 31 without pension and other
Yes.
benefits. Para?
Para 21, you will also find that several other writ petitions were disposed of. While dealing with those matters, the court deprecates the action of the state opposite party. The state opposite parties have not apply the direction given by the eligibility. Having such a here is not required. Para 22. In view of the above, the state opposite parties are directed to comply the direction given by this court within a period. This court means in other writ petitions.
So OJC 12017 is filed by the petitioner.
12, that is available at page, para 20.
That was filed by the petitioner.
Why should we condone the delay?
Procedural.
No, is there any merit in the appeal?
Merit in the appeal is, my lord, your lordship, kindly for a moment, your lordship, kindly see page 35, the quoted judgment last paragraph. In view of the above, we modify the order of the tribunal to the extent that opposite party shall be brought over to the regular establishment for at least 1 day by creating a supernumerary post. If necessary, and accordingly, he shall be extended with the pensionary benefit as would be admissible to him. The entire exercise shall be completed within a specific
We
period.
have done that in a number of cases. No, I think similar order has been passed in a number of cases. You have not challenged the order in all the cases, I think.
About that, I don't have.
You have to take instructions because
Yes, whether it has been challenged or not,
yes, you take instructions
Yes.
specifically regarding that.
yes.
So after 600 days, why should we condone the delay if similarly situated persons have been granted the
I
benefit?
take interest in that.
Yes.
Yes. To be correct.
This is the case on 2-1 or 9. When do you want? 9/1/2025 to enable Mr. Bimbisar Das, learned additional government advocate, to take instruction.
Item 29.
29, this is that case, your lordship may kindly remember, your lordship wanted me to take instruction as to whether for condemnation of delay of 1,055 days, whether the department is agreeable to give cost of 1 lakh. I have received the instruction.
They are ready. They are ready.
My lord.
On this, we will issue notice.
Present intra court appeal filed by the state of Orissa is barred by limitation. There is delay of
55 days.
56.
1,056 days. Stop. Learned counsel, Mr. AG, Mr. Bimbida Das, and AGA appearing on behalf of the appellant has submitted that the order impugned has far-reaching consequences, and in the interest of justice, its correctness should be tested in the present intra-court appeal. Stop. Since we were not satisfied with the explanation given in the application seeking condonation of delay, we had a delay. We had observed when the matter was earlier taken up on so and so that we may consider condonation of delay if the state agrees to pay a cost of rupees 1 lakh. Stop. Mr. Bimbidar Das submits that the state is ready to pay a cost of rupees 1 lakh for condonation of delay. Stop. Issue notice.
I have received a letter on.
Written instruction.
Yes, yes.
Say, 4 weeks, 6 weeks. So 20.
6 February. 6 hours.
Sorry.
Your lordship.
6/2/2025.
Item not 30.
There is a delay of 162 days, your lordship, filing the writ of appeal.
Yes, what is the issue?
Just my lord, I purchased a vehicle.
Purchase the vehicle, then
Purchased a vehicle, taking loan. And in total, there are 59 installments. I have paid some installment, but I have not paid some.
Vehicle has already been sold in view of award passed in arbitration proceeding. My lord.
But kindly have a glance to the impugned order. That it is, my lord, that when the petitioner will pay the amount, it will be released in his favor of the petitioner.
so now they have sold.
No, my lord. Yes, my lord.
Then why did you make that submission before the court?
I have taken averment in my counter affidavit that arbitration award has been passed.
No. Thereafter, arbitration award passed, vehicle sold. Had you taken that averment? Let us see your counter affidavit. During pendency, you sold it. If there is no interim order, we can understand.
My lord.
Where is your?
Before appearing in the writ petition.
Please show me your counter affidavit where you have stated that the vehicle has been sold. Paragraph 9.
What is an interim order? order dated 26 to 2024.
Please, one.
Not stated regarding sold by.
Delay is only 147 days. You pay 5,000 rupees cost you pay, then we will see if the writ appeal will entertain or not. So where have you stated that the vehicle has been sold and when has it been sold?
In the counter affidavit, I have not.
In your writ appeal, you have stated it has been sold. When?
On 7/1/2024, you got.
7/1. So after passing of this order,
Before passing of that.
during pendency of the case, you are saying there's an interim order?
No, yes, my lord. On the interim order was passed on 26 to
Yes,
20.
the order has been passed on 13/5/2024.
Yes, Lord.
Yes,
Interim order was
Before
passed.
that, before filing of writ application, the vehicle has already been
have you
sold.
given any documents?
Madam,
Have you given any documents? Showing change of ownership or payment
Why
of
did you
fee?
sell the vehicle? Why did you sell the vehicle when there was an interim order?
before interim order, the vehicle has been
Before
already.
the interim order was passed,
Before filing of writ application, the vehicle has already been sold, madam.
but in the counter affidavit?
Nothing has been said.
The counter I have not, I have forgotten to.
No, it is all right. You are challenging the maintainability, we understand.
The writ is against the private person for that reason.
So you are the private person who had appeared.
Madam?
Did you take that plea regarding
Yes, Lord.
maintainability?
Yes, Lord.
What has the court said?
That has not been dealt with, madam.
Item 30. Mr. Prakash Kumar Mishra.
Your Lordship, para 3 I have stated regarding.
And why was the delay? If you were a party in the thing, you were heard. So why the delay? How have you explained the delay? Have you given sufficient cause? Or it is like the state government's IA? Paragraph 4.
Paragraph 4, madam.
But you'll file documents regarding change of ownership when you did it. Heard.
But active, I.
No, you'll do it. Since you have not given it, you'll do it.
But yes, my lord.
Yes.
At the time of passing of interim order, that no third party interest, my learned senior was conscious.
Please consider that. Only the delay matter we are considering today. Heard Mr. Prakash Kumar Mishra and counsel for the appellant and Mr. Abhilash Mishra, learned counsel for the respondent.
So, but why don't you seek review of this order? See, this order was passed under the impression that the vehicle has not been sold.
Madam.
So you see, file a review application. Seek review. Otherwise, the sought order based on concession, it seems.
Yes, sir. Your Lordship may permit me.
Writ appeal and IA detail message like that. Mr. Prakash Kumar Mishra, learned counsel for the appellant, full stop. He submits that apart from challenging the maintainability of the writ petition, it is also a fact that the vehicle in question had been sold when?
On 7/1/2024.
On 7/1/2024, before filing or what?
Before filing of writ application.
Before filing of the writ application. Considering the said submission, the writ appeal is permitted to be withdrawn, granting liberty to the appellant to file an application for review of the order. To seek review of the order dated so and so to so and so, passed in so and so, so and so. All right. The said observation, the writ appeal is permitted to be withdrawn. Yes.
Item 31.
21 delay. 21 days delay, my lord. I have submitted, my lord, I have supplied the. I have submitted the petition.
Wait, let him submit, yes.
It is considered 21 days.
121 or 21?
Only 21.
21 days.
Appeal in filing time, because of the certified copy has not been filed, a Xerox copy has been filed. It's part of the.
Yes.
copies.
You have objection to that? Delay has been shown because he filed the certified of
Just
the.
now I have submitted the copy, my lord.
No, but you don't understand his submission.
My lord, the case is disposed of in the month of September.
Yes.
In month of October, he has filed the copy. And allegation is 21 days delay. But certificate copy of the order is filed 2 months after.
Yes.
Alright.
Have you never done that? And why is it filed without the certified copy? To save the delay. So it's 21 days. Who are you?
It's a private. I'm for the.
No, who are you?
I am the
Considering
affected
whether
department
we'll
of-
impose cost or not, that's why we are asking. We are condoning the delay, all right? Private party, so no cost, otherwise we would ask him to give cost for 21 days also. Heard Mr. J.K. Kuntia, learned counsel for the petitioner, and Mr. Akshay Kumar Pandey, learned counsel for appearing on behalf of the
Open number 4.
respondent number 4. All right. So you appeared sumotor or after
Caveat.
Okay. Who has entered appearance through caveat, full stop, considering the explanation advance in the IA for the delay in filing the writ appeal, and in the interest of justice, we are inclined to and the period of delay, which is how many days? 21 days. We are inclined to condone the delay in filing the writ appeal. The delay in filing the writ appeal is accordingly condoned. Full stop. The IA is allowed and disposed of. A copy of the appeal memo may be served on Mr. Pandey, learned counsel, by. You have it.
Already, sir.
The copy of the appeal memo has been served on Mr. Pandey, learned counsel, in court today. This is the case of fresh admission 991. How to get ready?
Minor.
On 15 or 16? Hey, calendar.
Let's say on 9 Suma.
Monogre teki kare padibo na, so kote depe se. Ha, thank you.
10th or 11th. 9 I will not hear.
Saturday, you want to come to court on 16/1/2025.
Item 32.
Pardon, my lord, I assume 30 vehicle was sold on 20th January. I have stated 7/1.
Okay.
20th January.
This item 32
Item number 32.
is not there. We'll take it up after recess. We'll dictate the order after recess. All right? Yes. Oh, you're there.
Mine.
You're also there in that case. All right, after recess, we'll
Yes.
take. Orders matter over.
Number 2 to be.
Item number 2.
Item number 2.
It will have to say something in addition to what was.
Yes, my lord.
Yes.
My lord, in view of section 23C of the MMDR Act, read with rule 17
Just
of
one
the.
moment. Let us open that.
My lord. Capital C.
Rule 20.
3, capital C.
Section. Yes.
Power of state government to make rules for preventing illegal mining,
Okay,
transportation,
you are
and
referring
storage
to-
of minerals.
You are referring to 23C. Yes.
Then, my lord, read with rule 17 of the 2007 rules. citing which the revisional authority has,
So 23C, the entire section or 3?
yes, 23C, my lord.
23C entire.
The state government may by notification in the official gazette make rules for preventing.
Thereafter.
And thereafter,
Same section, subsection.
yes,
23 is rule making power and 23C subsection 3, 23 subsection 3, notwithstanding anything contained in section 30, the central government shall have no power to revise any order passed by a state government or any of its authorized officer or any statutory and any authority under the rules made under subsections 1 and 2.
yes,
For this reason, my lord, the revisional authority has renounced its jurisdiction.
yes.
And my lord, 17, rule 17 of the 2007 rules.
Just one moment. When this was inserted in 1999.
Yes, my lord.
So till today, the revisional authority has not entertained any revision pertaining to.
Rule 7, my lord. If the state government has framed a rule, my lord, the state government will deal the matter in accordance.
Understood. So
Ma'am.
till date, the what is that mining tribunal has not entertained any revision pertaining to where this OMPTC rules are involved. What do you mean this?
I don't have any information as of now
That is why we are asking you.
for this
See,
matter, my
that
lord.
inquiry,
I'm prepared, my lord.
that inquiry was for a different reason. Because in most of the cases, the revisional authority is disposing of the matters in similar way. So that is one aspect. So if the revisional authority has no jurisdiction, you have all the powers.
Yes, my lord. That's why I'm attracting.
You
Your
have all the
lordship's attention.
powers, Mr. Counsel, since you have all the powers, then this is the submission made by Mr. Parija that you should have followed the principles of natural justice. You could have assigned reasons. You could
Yes,
have.
that's
This
another
is the submission. There are two aspects.
two aspects. Yeah, two
One, the power of the
Yes.
revisional authority, and the other is your action. So if he does not have any choice,
My lord.
like no revision, no.
That's why I'm attracting your lordship's attention to rule 17 of the rules, my lord.
No, so you are the final authority.
No.
No, I'm not the final authority, my lord. Appeal provision is there.
All right.
Appellate authority is there, my lord.
Yes.
Rule 17 of the rules, my lord.
Which rules?
That 2007 OMPT, that
Arabaita.
Yes.
2007 Orissa Minerals Prevention of Theft, that rule, my lord.
Yes.
Rule 17, your lordship may see kindly,
Yes.
is an appeal. Any person aggrieved by the order of the competent authority made under Rule 6 and Sub-Rule 4 of the Rule 10 may within 6 days from the date of receipt of the relevant order defer an appeal in Form P to the Director of Mines if the order is passed by the Deputy Director of Mines, Mining Officer, and to the government in the Department of Steel and Mines in the order is passed by the Director of
So
Mines.
in this case, the order has been passed by whom?
Order has been passed by the Deputy Director of Mines at Annexure 12 at page 883 and 83, 81 and 83.
Annexure 12.
Annexure 11 and Annexure 12, both. Same date order, 14/12/2023, Annexure
Yes.
11
Yes.
and Annexure 12. So these orders can be assailed
Yes.
under Rule 17 of the rules in appeal.
Yeah.
Yes.
PTSIMR-PSTT rule
Yes.
has been framed by the Orissa government. Any other state? Similar rules must have been framed by other states. That probably you've not been able to check.
Yes. The revision authority has cited 23C and
Yes, yes.
yes.
That was your objection,
Yes, yes,
state
yes.
government's objection,
Yes, yes,
that is
yes,
right.
yes.
But his stand is that since royalty is involved, so that has to be decided.
Let them approach the appellate forum and thereafter they will have this honorable court.
So that without deciding, how can we say?
What the appellate forum will do? What will the appellate forum do? How the appellate forum will decide?
Whether this order is illegal or legal, right, correctness of this order passed by the
Correctness of
deputy
order
director. of
even
finance.
we cannot decide. Because you have not assigned reasons. And the appellate authority cannot supplement
Yes,
reasons.
yes. My lord, lordship may see.
So, if you come to 23C, the rule-making power is confined to prevention of illegal mining,
Yes.
transportation, and storage of minerals.
My lord.
So you regulate that only. And while exercising that power, including the power of regulating storage of minerals, you have met the provision under 13(7), 10(7),
Yes, sir.
10(7). And 10(7) says that if the lessee declares to pay highest rate, so this is how you regulate. But again, the royalty, whatever royalty is to be paid under 7, that is to be paid by virtue of section 9. So you regulate, this is how you regulate stacking and sampling.
Yes, Lord.
Yes, Mr. Parija, you
Correct.
had
Yes,
made an application for exemption,
correct.
and that was allowed also.
Yes, madam.
When that was allowed,
Yes.
then you are required to pay at the highest rate.
Well, there are two things. First, let me deal with the question of appeal and whether under this act any royalty can be levied. That's the larger question which your lordship is supposed to decide. Kindly see these rules for us.
Under
This rule-
this rules.
Yes, sir. Under these. So let us first see, my lord, because he made a submission, there is an appellate provision. So let us see, my lord, section 17.
Section six.
Because the argument was
Yes.
that under 17 there is an appeal. So let me deal with that first. My lords have 17 minutes. Kindly see, any person aggrieved by the order of the competent authority made under Rule 6. So let us see what is Rule 6. Because that is one of the orders which can be appealed against. And if your lordship sees, my lords, Rule 6 is disposal of applications for trading license. Your lordships have it, my lords. I apply for a trading license, that is not granted. I file an appeal.
Yes.
Now let us see what is the next one. Then sub-rule 4 of Rule 10. My lord, am I with your lordship now? So
Yes.
6 doesn't apply. Now let us see what is 410(4). Your lordships have 10(4), my lords.
Yes.
So therefore, in case of refusal of the application made under sub-rule 1, the competent authorities shall communicate reasons. Now what is 10(1)? 10(1) is the grant of form H. My lords have 10(1), my lords. Rule 10(1). My lord, the Chief Justice has Rule 10(1).
Yes.
Yes. So what is 10(1)? Any person, kindly see, any person other than the lessee. Am I clear, my lords? Other than the lessee who wishes to transport or remove the mineral from any place shall make an application and complete in all respects in Form H. And if that person who is other than the lessee is not granted, that will be under Rule 4, Sub-Rule 4. My lordships have it, my lord?
Yes.
So therefore, 6 goes, 10(4) goes. Now let us see Sub-Rule 5, because that gives some other eventualities where an appeal can be filed. Your lordship may now see, my lords, authority under Rule 6. Your lordships have already seen Rule 6.
Yes.
Your lordships have seen 6, my lords. Now your lordship may see 8. Let us see what is Rule 8.
Yes.
Rule 8 is renewal of license.
Yes.
The license can be renewed. And if a license is not renewed, then there is a provision for appeal. And now we are left with 10(4). Because this 4, this sub-rule 5 of 17 is actually an exhaustive Rule 3. Am I clear, my lords?
Yes.
So therefore, these are the orders which are applicable. Have I come before your lordship saying that I have not been given a transit permit? Am I saying, your lordship, that they have not given me an application? My case is there any provision under these rules, as it rightly fell from your lordships, which empowers the state government to levy royalty? That's the short point. If the answer is yes, my lords, then I have no case. If the answer is no, apply. And kindly see, my lords.
May apply.
Because I'll tell you lordship why it won't apply. There is no provision under these rules, and rightly so, my lords, which empowers the state government to levy royalty. Under these rules, let us understand what we are dealing with. We are dealing with a case where the officer is saying, look
We
here,
are not dealing with minor vendors.
we are not dealing with minor. I'm grateful. So here is a case where the state government is saying that I want to levy royalty. Of course, you can levy royalty. But that levy of royalty will be under Section 9 of the MMDR Act. Am I clear, Millards? And therefore, if there is a levy of royalty under Section 9 of the MMDR Act, then the MMRD Act will give the forum where it will be challenged. My lord, if your lordship sees, this is only a 20-page rule. Rule after rule. Nowhere it is said that I have violated any of the provisions of these rules. Because for levying royalty, there is no provision here. And it can't be. The submission to the lordship, therefore, the revisional authority completely abdicated its power. That is something your lordships have to decide. Every day he is not disposing at all. Let us see the impugn order for a minute. It says, it does not say that you are required to pay royalty under rule so and so of these rules. I can understand. Because it doesn't have the power. How will he say so? And as it rightly fell from your lordships, 23C is only to regulate possession, storage, and trading and prevention of theft. Here is the lessee. Here is the lessee. And that rule your lordship just saw this.
That lessee cannot commit theft.
Lessee, I'll tell you lordship what. The scheme is this. The scheme is this. The minerals are produced within the leasehold area. Right, Milord? The obligation of the lessee is while removing to pay the levies prescribed under the MMDR Act, namely those three levies, 9, 9A, 9B, 9C. Suppose, Milord, the lessee does not pay those, he will not get a gate pass even to take the material outside. So these are all regulated. Milord, we are on the short question. There are two questions. One is that if there is a demand of royalty, there is no provision except Section 9 under which it can be done. And once that is correct, Milords, then it is revisable under 30. Let's see 30 for a minute. Section 30 says.
So for the present, we will just formulate that question.
Yes,
we will not go into that.
I'm grateful.
We will only for the purpose of passing an interim order, we shall test the correctness of the order prima facie.
Yes.
And then we shall consider.
And if your lordship sees page 83, the impugn order, kindly see it says that we have considered your show call not tenable. How can it be?
Yes.
Milord, this is not a mechanical exercise. You give a show cause, you give me a show cause, I reply, and you say not tenable. Milord, this is one of the facets of natural justice your lordships have held time and again. And Milord, the revisional authority, he entertains my revision, and at page 156, if your lordship comes, Milords, he grants me an interim order. But all that I am seeking is the same interim order to continue till the lordship decide the matter. Kindly see page 156, the last paragraph.
Yes.
My submission is somebody has to decide it. I'm grateful. I prepared a small draft issues that may arise. I can share one with my learned friend. If your lordships are. If it is of any assistance to your lordship.
It is the petitioner's represented application that it was granted captive mining lease for limestone and dolomite over an area of 893.55 hectare in Sundargarh, while registered sale deed dated 31/1997.
Registered lease deed.
Registered lease deed.
My lord.
Yes.
What should be mistakes in sale deed?
Oh,
I'm sorry.
registered lease deed. Certain facts are it is the petitioner's case in the present writ application that the grade of the limestone is not LD grade, bracketed less than 1.5% silica content under item 26 of the second schedule of the mines and mineral. Please take this mines and minerals.
Yes, ma'am.
Please take your seat, Mr.
I'm
Pai.
good.
Mines and Minerals Development and Regulation Act 1957. And therefore comes under the category quote unquote others. Stop. The rate of royalty payable for LD grade limestone is 90 rupees per ton, whereas for the quote unquote others, it is 80 rupees per ton. So stop. Earlier, the rate was different.
Yes, it varies from time to time.
Presently. Earlier, the rate of royalty for quote unquote LD grade and quote unquote others were 60,
63 now.
and 80 and 63.
You told us that
I'll tell you what she's doing.
This annexed.
It was 72 rupees and for 1.5% at page 172. And it was 63% for others. Page 172.
When
It was 63 rupees.
when the lease agreement was entered into initially. Then
But it was sometimes in 2012. In 2012 minutes.
So was it when the lease agreement was
Lease is
entered?
50 years old.
Yeah.
After.
Stop. It is further case of the petitioner that who later dated 14/12/2023, a demand notice was issued to the petitioner towards differential royalty, DMF and NMET at higher rate of royalty, that is 90% per ton of limestone in respect of the mines in question. So stop. The said demand notice is apparently based on SLES report,
Yes, we'll at the top means.
based on an SLES report of SLES team, state level. What is that? Evaluation squad.
State level enforcement squad.
State level enforcement squad. Stop.
22 or 23?
23.
23.
Conducted in 2023. Stop. It appears that on 14/11/2023, a so-called notice was issued by the Deputy Director Mines Rourkela, requiring the petitioner to explain as to why, based on the said SLES report as to why an action should not be initiated for violations observed by the SLES. The petitioner was also required to appear before the Deputy Director on 29/11/2022. The petitioner responded to the said so-called notice dealing with the points raised, points mentioned in the said communication dated 14/11/2023 on 18/11/2023. A plea was specifically taken on the question of payment of highest rate of royalty at the rate of 90% per MT. No, they were demanding
90 rupees.
90 rupees. 90 क्या लिखूं? 90 rupees. the Deputy Director passed an order on 14/12/2023
There are two orders, my lord.
Which order?
Annexure 11 and Annexure 12.
23 and passed two orders on 14/12/2023 by memo number 3721 and 3773.
My lord, it is 3720.
3721.
No, I'm sorry, my lord, your lordship is right. The first one is 37. First one is 3720 and the second one is 3772.
Yes. In the communication issued by memo number 3721 dated 14/12/2023, the Deputy Director communicated to the petitioner that the so-called reply filed by the petitioner was not satisfactory and therefore he was required to pay a royalty at the rate of 90 rupees 90 per metric ton DMF and AMT of rupees 11, 28. Is it 28? 11, 28, 87, 200, 3, 38, 96, 160, 20 and 22, 50, 744. Some discrepancy may be there. It can be seen from here. 1129 crore. And then 338, 96, 22, 59, 744 respectively.
Yes, ma'am.
To the communication of the same date by memo number 3773, the petitioner has been directed to deposit the differential amount of royalty, DMF and NMET for the period 31/3/2012 to 30/11/2023 within 15 days of the notice. The petitioner had preferred a revision application before the Revisional Authority, Ministry of Mines, Government of India, giving rise to revisional case number RA22.
RA22. Your lordship will get it at page 156. RA22/02/2024 RC1.
Page 169.
In the RC22, RC22/02/2024 RC1. The Revisional Authority passed an interim order on 18/4/2024 directing the state government to charge a rate of royalty at the rate of 80% per ton.
Rupees 80, well,
Rupees 80.
80 per ton.
Rupees 80 again percent. Rupees 80 per ton till the case was decided. So stop. The revisional authority clarified in its order that the petitioners shall be liable to pay, would be liable to pay additional amount if due, comma, depending upon the outcome of the revision proceeding. So stop. The revisional authority finally disposed of the revision case as not maintainable on the, which annexure is that?
Well, page 169.
Which annexure?
Annexure 70.
Page 17 starts from 168.
17.
168. Annexure
Annexure
17.
17 starts from 168 onwards.
169.
And your lordships will see the finding at 170, para 4.
9. Observing as follows. 3 and 4 at page 17, 774. Oh, stop. Mr. Parijal and senior counsel appearing on behalf of the petitioner has submitted that the revision application was wrongly of the MMDR Act, MMDR Act confers upon the power, confers upon the central government power to revise any order made by a state government or authority in exercise of the powers conferred on it or under this act with respect to any mineral other than a minor mineral. So stop. The mineral is question, comma, indisputably, comma, is not a minor mineral. So he has argued that the royalty for the mineral in question is payable under section of the MMDR Act, and therefore the revision application was maintainable, which has been wrongly, erroneously rejected by the revisional authority. Stop. He has further argued that in any view of the matter, the impugned orders dated impugned orders are 81,
14, 12, 23 minutes.
impugned orders
12.
by memo number so and so dated 14/12/2020 and memo number so and so 14/12/2023 are patently illegal for the reason that they do not disclose any reason at all as to why the so-called replies submitted by the petitioner was not acceptable. Full stop. The orders being patently, being manifestly unreasoned and therefore in violation of principles of natural justice requires interference by this court also for the reason that the revisional authority has declined to entertain the revision application. Learned AGA representing the state of Odisha has argued that the petitioner has a remedy of appeal under section 17 of the Odisha Minerals bracketed PTSI MRPSTT rules 2007. Full stop. He submits that under the said provision, any order passed by said provision, any person aggrieved by an order passed by the competent authority can be appealed against before the Director of Mines. Full stop. In response to the said submission, Mr. Parija has submitted that that section 17 of so and so rules is applicable only when the order of the competent authority is met under Rule 6 and sub-rule 4 of Rule 10 of the said rules. So stop. That's all, nothing.
This, actually, under 5, there are 2 more provisions, 8 and
He
9.
has also submitted that no appeal would lie against the order passed in the present facts and circumstances by applying Rule 17 bracketed 5 of the rules. So stop. What are the questions? Right? Questions which you have
I had
created.
given a sheet.
Based on the pleadings available in the writ petition and submissions advanced on behalf of the parties, certain questions of seminal importance on the point of jurisdiction of revisional authority under section 10 of the MMDR Act, when the issue relates to payment of a royalty under section 9 in relation to the minerals in terms of Schedule 2 of the MMDR Act have arisen, which shall be considered later after the state files its detailed response. So stop. which are as under. We are taking from your note
Good.
question number 1, question number 2, question number 3, question number 4.
Well,
Next. A prayer has been made on behalf of the petitioner for interim stay for an interim relief in view of the demand notices issued on
2 dates, no?
one date. What is that?
14/12/20.
14/12/2023.
14/12/2023
Next 12.
on the ground that since the orders are non-speaking, without taking into account, without noticing and discussing the points raised by the petitioner in the so-called reply, comma, no coercive steps should be taken on that basis.
You have paid as per the earlier demanded rate.
Yes, yes.
It has been argued that the petitioner has bid the royalty at the rate of
Rupees 80
rupees 80
per ton.
rupees 80 per ton. Full stop. He has per ton. Full stop. A specific point has also been taken that the impugned orders are based on a report submitted by the SLES Team 2, which report was never made available to the petitioner, and the petitioner's reply to the so-called notice was merely based on the points mentioned in the so-called notice. So stop. Next, we are prima facie satisfied that the impugned orders have civil consequences, whereby the petitioner has been asked to pay a royalty at the rate of 90%,
Rupees 90.
at the rate of rupees 90 per
Ton.
ton,
Empty.
Metric
per
ton.
metric ton. But why it is done there in the schedule?
It is actually empty.
It is yes, empty.
Volume.
क्या लिखें? From a retrospective effect, and is therefore in breach of principles of natural justice. So stop. Further, during the pendency of the revision application, there was stay
Yes, ma'am.
of
Page
the
156.
orders which are impugned.
Page 156.
Orders which are impugned in the present
Annexure 15.
writ application. So stop.
They said you continue to pay 80.
Accordingly, we direct Full stop. List this matter on how much time will you take? 4 weeks? 4 weeks. Full stop. In the meanwhile, a counter affidavit must be filed on behalf of the opposite parties. So while filing the counter affidavit, the state opposite parties shall keep in mind the questions of law framed herein above. So stop. Next. Till further orders, the no coercive action shall be taken against the petitioner based on the said two impugn orders. We are giving one liberty to them, Mr. Parija. The opposite party shall, however, be at liberty to recall the orders which are impugned and pass fresh orders dealing with the show cause reply filed on behalf of the
Very fair.
No, that's all.
Well, I have become very cautious since yesterday. Everything is going there. No, my daughter called me last night. What are you doing?
What are you doing? So that, which you said
That
that,
compensation which your lordship did not hear.
oh, that, what she heard.
Yet I think she was not working yesterday. Grateful man.
Oblige mail. Oblige.
Item number 1.
Item number 1, may I pray for the matter to be taken up in January, but there are similar cases of Mr. Padit, where those numbers were missed out by me, because I was not.
All right. So when do you want?
I think I should continue.
As requested on behalf of the Commissioner Justice matter on second week of January. Yes,
2 weeks ago. 2 weeks.
second week of January.
Deeply grateful.
Item number 3.
First item 1514, the medical application matters, there is delay of 543 days. This is regarding regularization.
Item number 3. Yes, make your submission.
Item 3.
Delay of 543 days matter regarding regulation medical application share.
So we will pass a composite order on limitation and made it both.
Otherwise, pass, that under scheme government has made provision for regularization. And in this case, the question raised by the state that the person concerned have not passed from the institution which has AICT recognition, approval.
Then we have decided. Which is the input order?
Page 45, the input order para 11 medicine matter. Page 45.
The list I had given, are those matters listed? I've given you a list way before yesterday.
Yes, ma'am.
Okay, thank you.
So this order has been set aside. WPC 333301.
My lord.
That has been set aside. Then what can be done? Where is that order?
That is attached to writ appeal. First one. Item 1514 of 2023. There is appeal 687 of 2020.
Eight order.
It's appeal. One file is here. The first one after the list. This one. Page.
Yes. Yes, there is nothing, Mr. Nothing remains.
Common judgment has been passed, that has been set aside.
Sub-item, read up copy not sub.
You have to give him a copy.
Okay, sir. By tomorrow.
By tomorrow.
We will take up the matter tomorrow then.
In course of the day.
Sir, give him a copy.
Yes, please.
Hear it tomorrow. Tomorrow we will take up. 10:30.
Okay.
Other matters are there. Other matters are there.
Yes,
Connected matters.
Connector matters are also there.
In other case, 1753, there is delay of 367.
No. Other matters which are not listed.
Sir, we cannot pass any order without hearing the other side. So let him come tomorrow. We'll give him a call. Friday.
Item number 4.
Which one doesn't have a copy? Which one?
With this matter.
Just Councilman and I.
It was heard. Only whether ADM actually was supposed to be put in charge and that was the stage.
In fact, my lord, there are 4 cases, 4 writ appeals, but the basic structure starts from the writ appeal number 1528 of 2022. That is the case where the Honorable Single Judge holds that the period which was spent by the governing body with the protection of the Honorable this court and protection of Honorable Appeals Court is counted as a term of the governing body which is challenged in the 2022 writ appeal. If that is to be taken first mind.
That means we have to pass, make some interim arrangement.
Yes, Your Lordship. In fact, one of the orders which they have challenged, they have submitted before the single bench that we shall not press this application, this writ appeal. That, if Your Lordship remember, we had shown that. So therefore, after hearing everything, Your Lordship says that they perpetually have continued. We even sent names today of people who have continued for so many years. And there, Your Lordship.
Which district is this?
Baleshwar.
Baleshwar.
And therefore, as the powers are there, the ADM to be put in charge. And then only the names to be sent, if you all
The last occasion, your lordship proposed that one officer may interim arrangement will be made by keeping some officer. Thereafter, certain period will be for reconstitution of the governing. That was the view your lordship expected from last.
Tomorrow,
Just to
can you
refresh,
suggest us a name?
which officer? Normally it is the ADM.
Stadium.
We will not leave it to the government. Give us 3-4 names, we will incorporate.
Names with the designation.
Yes, can I give just after recess?
Just after this or tomorrow even.
Yes, ma'am.
3-4 names we will select.
Yes, ma'am.
We can constitute the governing body also.
My lord, sir, the main question is, my lord, the term.
Forget that. The main question is the institution.
Yes, my
The
lord.
main question is the persons who are studying. The college is not about your the enjoyment of your privileges. The college or any educational institution is about the teaching. So this is how, if you fight amongst yourselves, then you should be kept out.
Well,
This is tough.
Interpretation, what is term?
With the due respect, my lord, there is no fight between the managing committee itself, governing body itself.
Yes,
There's a fight, my lord. It appears.
there is no fight. There is
Outside
fight.
the governing body.
There is no fight. May not be fight from the person outside the governing body, but
Inside they are happy.
you are misusing somewhere.
No, the statute provides 2 terms.
Now there's two,
If you calculate it as 4 terms, I think.
almost 2 decades if 2 years can be covered.
Oh, so 5. 5 terms.
2 decades.
According to you,
What is term?
1528 is the main matter. 1528.
Yes, but 1528 of 2022 is the basis, my lord, which has crept in according to taking this as the basis. The other single bench has passed the order that the term has expired, so therefore you go with that. When the matter was pending here, my lord.
You must be having so many other things to do. Why are you so much interested in this?
And they are exercising full financial powers, Your Honor. That's now. They have made financial transactions.
Therefore, you leave it, do something else. Allow the studies to continue in the college. Yes, tomorrow.
Item number 5.
But I'm requesting for an adjournment of this matter.
When do you want?
This is the last.
I'm supposed to file some government circulars.
But Mr. Rath, this has been adjourned, so.
Twice. Twice. Adjourned twice.
What is this matter?
But it's regarding allotment of a land. The restriction.
No, it's a cover matter, Mr. Rath. Yes, in fact, in similar circumstances.
In fact, there is a government circular which has condoned all these periods. But that circular I am just to bring to my lord's notice. That will not be covered by that. The government circular has not been considered. I have with me. I'll just file it with a leave from the lord.
Let us see. So every aspect has been taken into account in that. Could we get that order? Could you get that order?
Hello?
The order of the revision bench, could you find that? Do you have a copy of that order?
That Honorable Supreme Court, sir.
No, this.
That is observed in page 86, my lord.
Not Malati Vishwas of this page.
Lord, I'll address it, but she may take it up on 23rd. In the meantime, I'll come ready.
As requested on behalf of the petitioner, list this matter on 2nd week of January. Yes.
Item number 6.
Final application. Considering the maintainability of the appeal. What type of document take up this matter first?
Maintainability against?
Appeal.
You are appealing for?
I am appealing for the respondent number 1.
This time. This time.
Who was the writ petitioner?
Yes, I am the repeat son. I am the repeat son. The Honorable Singh is passed on order. Now that is questioned by my learned friend. I am
questioning the maintenance of the appeal. Let's hear me, let's first in this case.
So this time you are raising the issue of maintainability.
Now, this first time I'm appealing.
Yes,
In that FA of question, you were saying that it is maintainable. That is
all right,
what-
let us see.
No, in that context, no.
All right.
That is not
Just
different context.
mentioning it,
No, in that
not
context,
related. Writ appeals maintainability, subject
no,
matter.
that is not in that context. In other
Oh,
context.
Mr.
Okay.
Sometimes,
Beloved, here, beloved, the private, the respondent one is the managing committee of a special schools. That is the
where
bank.
is the order first? Where is the order passed by the learned single judge?
Page 53.
Page 53.
The 57 is the relevance, I think.
Page?
Para 8, 9, 10 is the relevance. Para 8, para 9, para 10. Oh, that's a bit.
How is the writ appeal not maintainable?
But the issue, the controversy, Millard, I am the managing committee. My managing committee was taken over by the collector in exercise of power purported under your kind of.
Mr. Counsel, this writ appeal may not have any merit. But how do you say that writ appeal is not maintainable?
They are not the parties at their instance is not maintainable. This is my specific. My
They were
specific-
not parties.
They are not parties, and they are not necessary parties. Even although they are not necessary.
They are not necessary parties, that's a different matter. But has he filed any application for leave to prefer this appeal?
Yes.
He has filed the application. So we will have to hear that. How do you say something?
And second point, my lord. In that context, the second point.
And that application has been allowed. That application that has been allowed, then we will consider it.
That context, second context, my lord, the order. Well, also, kindly see, the order has already been implemented. Also, kindly see, just as the order.
Maybe order has been implemented, the correctness of the order will have to be seen. If the order is valid, it's valid. Not valid, we will have to go.
No,
Consequences will follow.
Just only 1 minute, my lord. Decision interim arrest.
Mr. Counsel, you are the respondent. You are arguing the matter as if you are the appellant. You raised the question of maintainability, and because of that, we allowed you to address maintainability.
Sorry.
So take your.
Sorry.
When do you want? Have you served a copy?
Yes,
of the writ appeal?
Yes.
Then we can consider on minutes.
Madam.
Here the present petitioner appellants. So they are the teaching and non-teaching staffs of a special school for visually and impaired school and hearing impaired school. On their complaint, one inquiry was held. On inquiry, it was found that there has been malfunction, there has been financial irregularities. Therefore, as read Annex 3, at page number 31, your lordship may kindly see. Director passed an order to make suitable alternative arrangement for running of the institution by other suitable agency, management or departmentally be made. Appropriate action against the present management for creating such irregularities may be taken. It may be, please be verified if amount sanctioned towards fooding charges of residential students and maintenance of cost of non-residential students have been credited to the account of the parents, guardian of the students of those specially two special schools, action taken in this regard will be implemented. This is annexure 3, the retabulation 1231 of P. Rossi's will. Because this order of the director is applicable. But instead of preparing an appeal before the secretary minutes, they straight away approach the honorable court. And the honorable single judge has passed the order. If you also will see, kindly come to page number 56. Page paragraph number 7, last paragraph.
When was this order passed?
This order was passed on 13/8/2024.
That has been implemented further
What we
inquiry.
kindly see, paragraph number 7. Paragraph number 7, it submits that on a complaint made by some of the staffs, an inquiry was conducted by the.
Yes, that we have seen.
Well, thereafter, Lakshmi kindly see, paragraph number 8, a
Yes.
fresh chance should be given to the petitioner to put forth his position against the allegation made against him. A fresh inquiry was directed to be made. What has happened? I am agreed by paragraph number 9. There the court has directed, honorable court has directed that a fresh inquiry is to be made, but no capping has been made within what time it is to be concluded.
That
And
can be-
handing over has been made to run the school.
That we will modify.
Yes, exactly. And another thing is that he has been allowed to run the school and the inquiry will continue for no time. That is why I am agreed with you. That is why people are saying.
All right, we will do.
And now presently, District Retro Society is running the institute for imparting education to special school. Government has made arrangement and District
The only
Retro
grievance is
Society.
no time frame was fixed for
Yes.
conducting the inquiry. That is the
Exactly.
only grievance.
Yes. Inquiry, it has been found that there has been irregularities.
The applicant.
One minute, one thing. Only I bring to losses, one is the legal one. That is the order of the collector. The collector can be the stain of my this case. The signs of tolerance. Legal one. And let's see, that is the referring to the secretary NGO, double PC number such and such, letter note such and such, advocate general, with reference to the above cited subject in connection with the order passed by the Honorable High Court of Orissa dated 13/8/2024 in WPC number 5509/2013, and to say that your NGO Punyasam is continuing in both school, special school and dine and give at your such and such campus without GIA, and you have not handed over any material, students or balance fund to the District Director Society Honorable, despite the order of the collector or such and such. You may apply for a GIA to both school to the SSB department for consideration. This is for information necessary action. So my respective submission, the order of the honorable single judge has already been complied, and the collector said that we have not taken over your institution, you run an institution, you apply the government for granting.
What about the inquiry report? What was the inquiry?
The collector said no inquiry. This order says because they said that that institution was not taken over by the Director Society. The you kindly see what is the order said. That order may be wrong, right? I am not saying what this order passed. As per the order of the single judge, now the collector said there is nothing, no requirement because you have not handed over the institution. So nothing. You can make application to the government for GIA. You kindly see that again.
Mr. Counsel, you are running the college, running the institution.
As per the collectors.
As per the collector. So what is the order of the court in paragraph 9?
Paragraph 9 says that you have to give the management to me because
Whether thorough inquiry has been done or not. Paragraph 9 directs the collector to conduct a thorough inquiry, whether this has been done or not.
one notice was given to me, I appeared, and thereafter the order was passed.
The order was passed.
Yes, this order. That
Whether the inquiry was conducted or not.
was conducted.
This is the inquiry.
This is the inquiry.
That he appeared, so that is what he is saying.
Whether that means a thorough inquiry or not, I cannot say, but I was called for and I appeared and the order was passed.
All right. List this case on 1st of January,
Second.
2nd of January. So in the present inter-court appeal, the appellant has put to challenge an order of this court dated 13/8/2024, passed in WPC number 5509 of 2023, paragraph 9 of which reads as under. So stop. We, for just adjudication of the present intra-court appeal, we consider it desirable to direct the district magistrate, the collector cum district magistrate Angul to file an affidavit as to whether he has complied with the carried out the order dated so and so
13/8/2022.
carried out the order as made in paragraph 9. Carried out the direction as made in paragraph 9 of the impugned order passed by the single judge or not. Within first 5 cases. Yes.
Item number 7.
I counter, I am the opposite party number 3, college balance.
I'm sorry for providing the copy. I have been instructed to appear on behalf of opposite party number 1 and 2.
Yes, you mentioned yesterday, we had asked you to get us, get
That is other
instructions.
matter, my lord. That is the lease.
Oh, this is the one he says
Yes.
is not listed.
Yes.
So the other one is listed today.
Yes.
I will
So same thing.
let the finally count in both places. I'm providing a copy in this place to the land households. So, on that one,
You've already served copy.
no, not so, no, copy.
Then how are they appearing if you have not served copy?
This item,
Yes.
I am instructed to appear, madam. Let them direct to copy, solve a copy, and then file there.
Admission wala.
No matter there appearing.
Item 42, I have instruction.
On the meaning.
Written instruction.
Who is for the petitioner?
I am for the British.
What do you want?
No, I am providing the copy,
Tell us
madam.
what-
Similar grievance.
Huh?
I have the similar grievance, they had that, for according permission to sit in this examination, madam. So, similar matter was there, madam.
How many cases have been filed?
This matter.
How many cases have you filed?
This matter, total 4 matters,
Total 4
4
filed.
matters.
And how many cases are going to be filed?
Once, that is.
How many are listed today?
Two matters, because this is a number.
Huh?
2 are in the diary stage.
How many?
These two matters and diary stage.
Waiting.
That is to be some difference are there.
And some student must be coming to you again. Many
How
other.
many will come once you know that?
How many? Do you have any idea? Just talk to them. Tell us.
As and when they.
Why should they study at all? List this matter on January 2nd week. So, let in the meanwhile the meetings be exchanged amongst the council representing parties. Yes, do whatever you want. Yes.
Item 42 is that case also.
Yes.
Yeah, I think so. This item I'm probably serving the copy today.
All right.
Has it not become infructuous? You wanted to appear in the examination which is going on.
Yes.
You wanted in January, so examination is going on.
Or it will become infectious after some
No,
time.
that is for the where semester games. Now there is IU which I filed. That is for the internal examination.
We understand, Mr. Khan.
That I explain my lord.
We understand.
Yes, conducted by the college. Conducted by the college, my lord.
Next.
Now, I am not subject to the result criticism.
No.
I am allowed in the.
I have some instruction, my lord. After scrutiny of at the university level, my lord, 46 students were found eligible for registration under Utkal University of Culture. filed notification number 26/9/2023. The petitioner was found ineligible on the ground of upper age limit for admission to BBA course as per the notification.
All right, all right.
18.
File your affidavit.
I will find out for you.
File.
Down to you.
Item 40. Item 42 to 10.
Nothing.
Item number 8.
Highly for amendment of the restitution. So there's this annexure 10 where there is a joint inquiry report submitted by the sub-collector. We are inadvertently missed out the challenge.
Have you served copy?
Yes, I have served a copy yesterday.
IA.
Yes, my lords.
File report. Yes.
So, this is, basically the writ is regarding the challenging the.
When did you file your writ petition?
Right, when? On 27th of October.
Huh?
27th of October.
And when did you file your interlocutory application for amendment?
On 17th.
Was it because of subsequent development?
15th of this. No, there's no subsequent.
Madam, you are filing in October a writ petition.
No matter.
In December, you are filing an amendment application. So keep on doing it. IA number? IA number amendment
17025.
allowed. Next. 4 weeks.
Item 9.
From yes, I am appearing for opposite party number 2, Airport Authority of India. The tender has already been finalized and the evaluator has already been issued.
To him.
To third party, RL Abhishek Private Limited.
And what is his grievance?
Prayer declaration.
Seven fractures. In view of subsequent development.
That is why the petition is not coming 2 days.
Fine.
None appears for the petition.
None appears.
None had appeared on the last date also none had appeared.
My name mechanic.
Yes. File for all.
I am for opposite party number 2.
You cannot record. Yes.
Item number 10.
My lord, in this case, the petitioner challenges the termination of contract awarded to him.
Termination of?
Termination of contract, my lord.
Yes, where is the order?
That is under Annexure 25 as to page number 101.
Yes. Yes.
Yes, my lords. My lords, the petitioner was awarded the contract and the agreement was executed under Annexure 1, my lord. As per the Annexure 1, I have achieved the target. What happened, my lord? The original drawing and design has been changed 4 times, which has resulted in addition of extra work for which no agreement was executed.
All right. So what do you want? That has been rescinded.
Because I was forced to resume the work when there is a flood in the river. This is a bridge work, man. I have intimated it to him due to heavy flood. There is a life risk. The work cannot be executed. After the rainy season, under Annexure 23, I requested to extend the time of contract and I undertake to complete this 25th March 2025.
Was there any arbitration clause in the agreement?
No, there is no arbitration clause. And that was pending. He has to terminate my contract. I require 4 months time to complete the work, my lord. Because due to heavy rain, the northern Odisha was under the flood, my lords. At that time,
That decision they can take. You cannot take.
Yes, ma'am.
Which order are you challenging?
25 annexure, termination and subsequent action,
What about 24?
24 is the
Submission of the third termination.
sorry, proposal. And the same person approved the proposal minus. Under his signature, the same person approved this proposal minus. And the so close reply I have given that has not been taken into consideration while passing the impugned order.
Submitted the proposal by annexure 24.
Yes, ma'am.
Thereafter, by letter dated 8/11/2024 of the chief engineer. With reference to that, annexure 25 has been issued.
Yes, ma'am. Same person.
You don't have a copy of letter dated 8/11/2024.
That has not been communicated to me, madam.
Page 98, your lordship. Annexure 24, your lordship. If I may read
We are
out-
seeing that.
Twice, this is the third termination, your lordship.
Third termination.
Third termination, proposal for third termination. And your lordship, in the above counters, it is to state that the work has been entrusted to Kiran Lakshmi Infra Projects by agreement such and such with stipulated date of commencement and completion 13/12/2017 and 12/6/2019 respectively. The agency has been executed the work of 3 crores 52.23 lakhs only as on date of interim deviation cost of 5 crores 36.49 lakhs, even after the lapse of 6 years, 9 months.
He has filed 3 for rent applications.
Yes,
The
yes.
earlier termination proposals have been.
Both times, the court intervention, your lordship, has been allowed provisionally. The agency has been allowed time up to 31/3/2024 provisionally to complete the work. But this agency is non-responsive to our show cause notices as well as reminders.
You can file a suit, Mr.
My lord,
You can file a suit.
focus I have filed.
You can file a suit.
My lord, always my lord, difficult, I am going to be blacklisted and my digital second signature is going to be blocked. I have so many, I am undertaking so many government contracts. I will be harassed my lord.
It is because of your efficiency. So try to be less efficient.
No, my lords, I have.
Because you were so
My lord,
efficient
your
that
lordship
this
can
order
see.
could work.
My lords, they have,
We will not interfere. You can file a suit.
no, my lord, I will satisfy your lordship. Why
Not
there is
satisfied.
delay, genuine delay, I will satisfy your lordship.
Genuine delay, we will not decide.
Delay, they have not taken into consider the so-called reply, but I have vividly.
Where is your so-called reply?
That is annexure 22 at page 90, my lord. But why there is a delay, I have explained in my so-called reply. That has not been taken into consideration. And because the local ML pressure, it is written in the annexure 24, my lords, the local pressure to resume the work. That's why the.
Let them file a counter affidavit.
Yes.
8 weeks time is allowed for the state to file counter affidavit. 8 opposite parties. Just this case 8 weeks. So to make it clear that we have not made any interim order and pendency of the present writ application shall not come in way of the opposite parties proceeding further in the matter. Yes.
Item 11.
The case of revocation of the NOC was granted for 4 years. Case of revocation without any show cause. The lordships may take your lordships to the impugned order, which your lordships find in annexure 6, page 26. This comes after the admissions.
No, but the students are not going to be adversely affected.
This year, students will be affected.
No,
However,
This-
students are already admitted in the earlier academic sessions, not the going on.
no, that can be clarified. However, the students already admitted in the earlier academic session.
If you
All right. Yes,
I will get instruction.
6 instructions, 1 week. 1 week. The petitioner in the present writ application has put to challenge an order dated 29/11/2024. A later dated 29/11/2024 addressed to the petitioner whereby the NOC granted for conducting courses of GNM, BSc-N, PB, BSc-N has been revoked for the academic sessions 2024-25 and beyond. So stop. When counsel appearing on behalf of the petitioner, when senior counsel appearing on behalf of the petitioner has submitted that the petitioner has already given admission to students in the said courses for the academic session 2024-25. Stop. Let a counter affidavit be filed on behalf of the DMET. Considering the urgency of the matter, the case is directed to be listed on January 1st week within first 5 cases. The meanwhile, counter affidavit must be filed. First off, the affidavit should also disclose the steps which DMET proposes to take for concerning the students who have already been admitted in the petitioner's institution for the academic year, academic session 2024-25. Yes, you tell us.
Has been revoked, found the fire certificate to be fake.
No, you're like, no, that's not the case. What happened is this NOC was there with a very valid fire certificate. When it came for a renewal, there was an ex-employee who really did not submit a fire certificate, made and submitted it. And when they started taking action, that was also stayed by a single bench in a fire certificate matter. Thereafter, they issued this. And this is for a separate course. That was for a separate course. They said merged it. But this NOC was on a valid certificate.
Course means fire certificate is one only.
Yes. No, your institution. The fire certificate initially for this NOC was valid. When it expired and they applied for another one, it was for a different course, of course, or a different building, of course. That's where the...
See, what we may do is that if we are not satisfied with your stand, we may impose cost on your institution to be for the like they will have to be compensated, the students. And again, if we are not satisfied, the students will have to be shifted to some other institution for that academic session.
All that I say,
If we are satisfied, the matter is in.
all that we say is, your lordships, the fire certificate issue was there since so
We'll
many
examine,
months.
we'll see that.
You did nothing. So only after admission you're revoking it for these courses.
That is incorrect. That you should not have done.
If you had to do it, you should have taken some decisions, we would not.
Or at the same time, you could have taken a decision to make some arrangement for the students who have already been admitted. For us, the studies of the students are more important than running of these institutions.
You put up my name on the portal, you allowed the admission, you allowed everything.
Therefore, madam, soon after. All right, madam.
Item 12.
But here the matter is regarding the housekeeping services which is being given by the CDMO for the district of Punjab. I'll just take your notice to page 24 where the eligibility criteria has been given. For the selection process.
So, what is your challenge?
Challenge is to the faulty selection process and a person who doesn't have the qualifications or the criteria to fulfill the criteria has been given, and when it is specifically barred under the eligibility criteria clause.
Who are you?
I'm also one of the bidders for the work. And I'm also qualified in the technical qualification.
How do you say?
Your Lordship may see page 24.
Yes.
Eligibility criteria. 2 and 3, my lords, I'm relying on. The second one says, if your Lordship will see in that table.
Yes.
In that box, second one.
Yes.
Consortium is not allowed. Now, what the person has done, if your Lordship should come to the page 90, a notarized acquisition agreement has been done, business acquisition, of a private firm with a private limited company, a partnership firm and a private limited company, which continue to file GST separately, everything, their entities are separate. And taking the experience and the value of work done by the partnership firm, the private limited company has been granted the work. Your Lordship should come to page 90.
And what about the other? Must have average annual income?
Yes, that also, my lord. I'll just.
Because of 2.
No, that is also, my lord. I'll just filing an additional affidavit because those documents were in the portal which could not be recovered. In the first 2 years, because this company was incorporated in 2020. The first 2 years, the return has been shown as nil. So he had 0 work. Third year, 8 crores. So even the average also, if we take 3 years also as 9 crores, then also he doesn't meet the eligibility criteria.
File your affidavit.
Lord, in the meantime, subject to Lordships, my lord, because they are going to issue the work order and the work will be started.
Maybe work must continue. Work
The
cannot
same
be stopped.
arrangement which is because the work is going on. Same arrangement, the Lordships may grant status quo also, though that the same agreement can continue. I'm not saying that the work should be stopped.
Ex parte interim order. Difficult, particularly in contract matters.
Your Lordships may say subject to result of.
Yes. This does matter on January. Chocolate counter affidavit will be filed on behalf of the opposite parties in the meanwhile. State opposite parties in the meanwhile. And the court will consider, whereafter the court will consider issuance of, consider requirement of issuance of to which private opposite party?
OP number 4.
OP number 4. It is made clear that any action taken based on the request for proposal by the advertisement number 1138 dated 18/1/2024 shall be subject to final result of this case. Stop. We also clarified that this order shall not be constitute to be an order restraining the opposite parties from proceeding further in the matter of award of contracts.
Additional affidavit of record, we have given the
File it.
financial credentials.
File it is registered.
You can also just mention that so that I'll.
When senior counsel states that an additional affidavit is going to be filed today. Let it be done.
Well, in the notice that I can include it, otherwise my lord, the notice has to go to the private opposite party.
So you do that.
So I can include, because unless your lord just mentioned that, that won't go along with.
Therefore,
Item 13.
Obliged. Then make it easy, Lord. My lords may kindly come to page 20. This is regarding e-auction of a quarry lease.
yes,
Page 20, my lord. And if my lords kindly sees page 21, there were two queries. We are concerned with the first one. Upward or handy.
yes.
Now, my lord, if your lordship, now kindly see page 28.
You are referring to?
And I was referring to page 20. This is the NIT 29.
No, there are two queries.
Yes, the first one. Serial number 1.
Yes.
My lords may now kindly see page 28. This sets out the eligibility criteria. My lords have it, my lords.
Just.
Page 28.
Yes.
Kindly see, my lord, the eligibility for participating in the auction shall be determined as per the terms and conditions. Eligibility in the auction provided in the rules. Under Rule 27(4)(a) and amendments made thereunder, A, you have to be Indian national. Lordships have it. Capital A, Roman 1. A person who is an Indian national shall be eligible to participate. My lords have it. This is 4.2.
Yes.
Roman 1.
Yes.
Now, Roman 2, the bidder shall submit either income tax return of the previous financial year certified by a chartered accountant showing his annual income or an amount less than the amount of minimum additional charge for the royalty together payable with the minimum guaranteed quantity for one whole year or submit a bank guarantee. So we have submitted an income tax order. Now kindly see 4.3. Only one application from one member of the family, company, firm shall be allowed. The eligibility condition shall be used for the purpose of determination. Now kindly see page 30.
Page
30. It says, paragraph 6, registration for e-auction. My lordships have it. So what are the documents I have to give? A, bidders to follow the detailed guideline for registration available in the MSTC portal. 1, I have to give a non-refundable application fees by treasury challan, 1,000 rupees. My lords have it. Now number 2 is B is EMD. And C, documents to be uploaded by the bidder for participation. My lordships have it. C, kindly see Roman 1, affidavit stating that no mining dues payable under the Act and rules made thereunder is outstanding against the petitioner. And then Roman 2, page 31, similar. Affidavit stating that none other than him, her in the family is participating in the bid process, particularly source if contrary is observed, the sale if any shall be rendered infructuous. Roman 3, income tax return of the previous financial year showing annual income for amount not less than the amount of additional charge offered in the royalty payable minimum guaranteed quantity pursuant to. Now kindly see page 45. Annexure 2, my lord, page 45.
Yes.
So if your lordship sees, it says bid application fee payment. So this is one requirement. Kindly see page 46. See, my lord, serial number 4. I have no mining dues, including dues anywhere in the country. That is serial number 4. That was another requirement. Page 46, my lord, serial number 4.
Yes.
Page 47, again serial number 4, stating that no other than in my family is participating in the bidding process. So these were the requirements your lordships had seen.
Stating that no other that.
English bhuli.
Then.
No other
Then
that in my family is participating in the bidding process.
no other than in my family, it should happen like this.
Yes, yes. Your lordship is right. Your lordship is right. Absolutely right.
No other.
Yeah, family I am only singularly doing it. That's what he's trying to say. That is the requirement.
No.
No other person. My lordship is right. Now kindly see page 48. My lord said page 48.
Yes.
This is the EMD. Your lordship should say remittance details, amount 49,000. This is just last but one, last
Yes.
5 lines. The remittance details, amount of 49,438 has been remitted as per the EMD. Remittance data, payment of pre-EMD by the bidders. My lords have that line.
Yes.
And now, page 49, the last requirement is the certified income tax return by the chartered accountant. So the chartered accountant is RK Banka and Company. The income tax return is over the page. 5051.
Are these the reasons for rejection of?
No, I don't know. What they tell me is, kindly see page 55. They tell me it is only rejected. And I asked for the reasons at the very next page. And in a similar matter, my lords, your lordships had issued notice, and your lordships had said that this will be subject to result of the writ.
Same petitioner.
Same petition. What had happened is that the lordships said status quo on the next date, but then a counter was filed that it has been cancelled because there was only one bidder
So that case.
in that case.
So that is pending.
That is
Disposed of.
in terms of.
So this is the retender.
No, this is another. Because from time to time, different queries come for us.
Yes.
Let's see page 8, paragraph 5. That is the case of the petitioner. We file a counter application.
Page 8.
You have filed.
No,
We
page
file.
five.
Page
Page
8,
eight.
paragraph 5. No reason is assigned.
That is what he said.
We'll file counter application.
And as per page 32(8), you have kept a clause in your tender condition that no reason be assigned.
Yes.
So you may not be required to give any reasons, but you will have to give reasons to the High Court.
We'll file counter.
Correct.
Does this matter on 4 weeks?
Can it be little earlier?
4 weeks means what? That's the earliest is 2 weeks. Nine.
You will get instruction, what is the reason for rejection?
Third party rights be created in the meantime. or subject to result, whatever you like.
Subject to.
Grateful.
Similar order can be passed, same.
Yes.
Disputes are same.
Only the mine,
Mine.
I will give the name of the mine, Your Lordship.
why don't you make the?
I will make it and give.
Item 14.
My Lord, the next case is a little more important. If Your Lordship sees minutes. All documents were filed. And if Your Lordship sees page 47, because I'm required to give a set of documents, it starts at page 46.
Is it, this is,
The next case.
Oh,
GD.
sorry. So this is the same petition.
Yes.
The one with something.
So if Your Lordship sees page 46 minutes, I make the bid application fee payment. And this is the company. And my lords may now see page 47.
yes,
And if Your Lordship sees, this is the same declaration that serial number 4, I have no mining dues.
yes,
And if Your Lordship sees, at the bottom of the page, I have signed this as Dhiman Chakravarti, Calcutta. Your Lordship may only note that much. Now kindly see the next page. I, Dhiman Chakravarti, GD Mining, etc., etc. I'm so sorry. If Your Lordship sees page 47 once again, it says, I, Dhiman Chakravarti, Director of DG Mining. Your Lordship get it?
Your case is that it has been rejected on the ground that it is incomplete.
He is saying you are not, no authorization has been given. That is the reason they are signed.
So in paragraph 1, you stated it has been rejected as incomplete.
Yes, that's what they say. I'll show you, Lordship, sir.
The reason. Okay.
Kindly see, page 47. The first line is Dhiman Chakravarti, Director of GD Mining. The Lordships have it, my lords. So he says serial number 4, mining due certificate. Now, page 48, the same person, Director, he gives an undertaking as serial number 4, as the Lordship saw in the other case. Now, my lord, he files that at page 49, he gives the EMD. And my lord, at page 51 is the income tax return. And there is something your Lordship must see in this. Kindly see page 53. Your Lordships are page 53, my lord. At the bottom of the page, he is signing the balance sheet. Only a director can sign as the director of the company.
yes.
Your Lordship has that page with us. Same thing at page 54, Dhiman Chakravarti, director, with his DIN number also in both the pages. And if your Lordship sees now page 55, which is form M, at page 56, he again signs as director. Your Lordship have it here. Page 56 bottom.
So director can be a capacity.
Yes.
And director can be an identification.
Either way.
Like any address.
Exactly. He is the director of the company.
He is director of the company.
Yes.
So he will be writing that even in his visiting card.
Yes. Here at least in the income
But that
tax
visiting card is not in his capacity as the director.
Not in the
Like,
income tax return. The principal officer of the
that-
company.
there you are
is
right.
signed.
There you are right. We were just referring to the affidavit.
Correct.
It says that so and so director.
Yes. So because under the Income Tax Act, only certain people can sign, and here it was also rejected. And when I asked for it at page 58, they rejected it. So we asked for the reason. They say at page 57 that there was no, kindly see not page 57. And the reason for rejection, what they have given is, if your Lordship sees from the bottom, just before that email of 3rd December 2024, in the absence of such, let me read it from the beginning. In this context, it is important to emphasize that authorization is crucial for ensuring the validity of the tender application, as a private company is a distinct legal entity separate from its directors or shareholders, The affidavit submitted involve representations made on behalf of the company. Kindly note, not made on behalf of the company. However, no document explicitly authorizing you to act on behalf of the company and participating in the tender process, such as board resolution, power of attorney was submitted in the online offline form in the absence of such explicit authorization. When I'm signing as a director and giving you all the documents, and I have signed the balance sheet which you also have, where is the question of a further authorization? I can understand.
But please come to the second paragraph.
Yes, madam.
Of the same page.
Yes, madam. In the
As per the tender requirement.
As per the tender requirement, outlined in Form M, specifically note saying, I'm grateful minutes. If the applicant is signed by the authorized agent of the applicant, the power of attorney. Suppose the company were to nominate Mr. Venugopal Mahapatra to file on their behalf, then that would require a power of attorney, not for the director. That's the point. Had he signed as the authorized agent, he would have been required to give a power of attorney. Here, the company is itself filing through its director. And if your lordship sees that Form M minutes, kindly see page 56. He does not say that I am the authorized agent. He says I'm the director. And you already have his signature in the income tax return.
Yes.
I will obtain instruction in this matter or may call on this matter 2 weeks after. Because the income tax return is signed by 2 directors. Two directors are signed in the income tax.
No, but directors can make application. They don't require any authorization.
I will examine.
The board resolution will be there in the table.
They have not filed any board resolution.
It is not power of attorney. Where is the question of giving power of attorney?
Even,
power of attorney will not be required.
even resolution of the board is not also filed.
That is not a requirement.
That is not the requirement.
I will take this.
The requirement is of filing power of attorney if it is being filed by an agent on behalf of. That is not there. File your application. Yes, same model.
Some protection in the meanwhile. Not
Same protection.
great. Grateful.
Item 15.
Challenging the rejection of the MSC on the ground that the fire, I have not given the fire safety certificate in the prescribed format. And take the.
But is that matter not over?
Yes, but here it's very specific. If your lordship would see very interesting issue. What they say in the impugned order, if your lordship should come to page 101, annexure 18.
So is this that case where you made allegation that somebody was given a combination of some person?
No. Here is a case where the DFO himself says that the building doesn't require a.
No, that is subsequently, but the background I'm saying, because there are a number of previous writ applications.
Yes, no, this is regarding only this NOC because of the date lines.
Withdrawn with the modification.
Yes.
Modification was disposed.
With the liberty.
The structure says that they have
With the
accepted
limit, yes.
that. So you are alleging that somebody is beyond the date it has.
Beyond the date. Lordships may see page 101. One line rejection order. Your application for renewal to impart the A&M GNM course for the academic session so and so is considered due to non-submission of fire safety certificate. Then your lordships may come to page 98 annexure 17. The lordships may see page 98. But however it starts. Because the criteria have been given, then however, as shown in furnace plan and undertaken inspection by a team of fire service officers on so and so date, and its structural parameters
doesn't meet the above mentioned criteria, that is educational building contain one block having G+1 floor and height of so and so with total built up area so and so approximately. In view of the above, as per Orissa Fire Prevention and Fire Safety Rules 2017, read with so and so, the aforesaid building so and so does not come under the class of education which requires a fire safety certificate. And then they say that whereas it is advised that required fire prevention and fire safety measures shall be provided in the building conforming to National Building Code of India for safety of life and property. So when the fire department itself says that the building doesn't require a fire certificate, safety certificate, the rejection of it on the very same ground.
Yes.
Lord, the certificate what has been given, but the area which has been given in its application for first. That is more than this is what is been pointed out here. And that is the reason why, and the plot which number it is given in the application form, that is also not correct in this one.
File your affidavit.
Yes, ma'am.
The certificate details do not match with the.
Yes, ma'am.
This case, second week of January.
The student's name uploading is after 31st of December.
I don't see how can they get that.
So it can be without prejudice, the student's name can be uploaded. I will also pass the order in item 11.
Some of the cases, sometimes that becomes very difficult. And finally, you don't succeed, or if the matter remains.
As you also said, ordered in item number 11, similar.
There has already been admitted subsequently.
So here also the admissions have been done, but the names have to be uploaded. That's all.
They have not given NOC, so admission.
So how could you do the admission without the NOC?
Your lordships remember that on the ground that they have been given admission for this academic session because the earlier fire certificate was there. Subject to lordships, but because if it can be taken up at an early date.
Let them file a
31st January or 31st?
December. No, on first week your lordships can fix it if also subject to because that is for them to grant the NOC. Seven. Deeply.
Yes, 16.
Item number 41 is the maximum remember.
Same question on the.
Sliding. 16 is different.
Yes.
Lordships remembers is that about that road and matters.
We are monitoring your case.
I'm so not can it be taken out?
My plan has been approved in the meantime, and I have written instruction.
Please give him.
No, they have sent it to on WhatsApp. I have some submission to make.
No, we will.
Take it up before I.
In fact, at least every day we are finding some development. So let it happen.
They have played when I call a trick on me and your lordships also. I will make a small submission. If your lordship can take it up anytime convenient to you, because that 2 o'clock they have come from outside.
Today, we will take up today.
We'll take that. We'll take out that matter.
We will take up today.
Anytime, give me 5
Today.
minutes.
Today.
Thereafter, if it is necessary, your lordship will
We will take up.
another.
We will take up. What have they done?
They have regular assured your lordship that 25 acres. Now they have given us 10.6 acres, and that too over a period of 5 years. Will it 5 years the work will be continued?
So you can't mine that entire quantity in 1 year.
It is not available because 25 acres, if they give us for 1 year, we can do it.
So what was
But,
the period of that area, the earlier one? The earlier one was for
1.5 year.
the same period you want.
Same period, larger area. Otherwise, 5 years they have given, and there is no material. We have to go deep down, and 5 years it cannot wait, na? Road construction, and we have a contract which will expire after 1 year.
So that even you supply for.
We'll consider.
Extended, of course.
We'll
These
consider.
are
You should also consider.
But 5 years
These are-
Think what he's saying, whether.
without material.
I'll communicate.
You just communicate. You just see. Sometimes, Mr. Monkey, things happen because of ignorance also.
Thinking also.
So it is not that
No, but
every time
the
motive.
order said repeatedly they told 25 acres were given. Now they have come out. There is something more than meets the eye, which I cannot vouch before this court.
All right, we'll take up.
16 and 48 again regarding that NOC where they have admitted their fault, they have said that we have overlooked the defect.
The PCI matter, Your
PCI
Lordship.
matter, madam.
The counter supports our case. They said, no, you did submit. We have extended. It was an oversight.
Cost on that officer, him online and.
And they have overlooked it. Somehow or the other, they have overlooked, so they have rejected
We
it.
will take up your matter to when.
When is it? It's there today.
It's there on the list.
They are in the list today, item 16 and 48.
Admissions are over.
No, my lords.
Admissions going on.
So they're going on. Their last date is, they had extended up to 10th of December on their own prayer.
Not extended.
Admission is over.
And Supreme Court order, they themselves approached the Supreme Court from April to October, then from October to 30th of November.
It has not been extended, if I remember correctly.
But they have filed the reply that they have overlooked. And we have submitted within time, prior to 31st of October.
It's taken after lunch. That's the first case.
On the basis of their affidavit itself, it can be disposed of. Is that okay?
My lord, item 47, if it doesn't inconvenience, we are filing our counter in course of the day. Copy has already been served.
It will come after. As jointly requested. As jointly requested, January second week.
7 days.
What can be done? Yes. Yes, Mr. Jain, please.
First, it will be enforced.
But
And by it will be enforced. And higher, there is no possibility of migration. That is what I have been.
Just a minute, just a minute. All right, we are disposing it off.
We are allowing it in view of the fact that the rules which were prevailing at the time of his admission. But yes, but it will not be taken as a precedent in any other case, confined to the peculiar facts of the case and its medical
Peculiar fact,
condition.
the student is suffering from cancer.
Okay.
When do you think so?
ଆଉ 300 ଅଛି।
16 and 48, they have filed the reply. Identical matter. 48 with the lordship can just.
we just look that apparently scanned copy hasn't come before lotships can take our copy.
What they have
Confidence
filed.
there. What they've stated is they've accepted, yes, there was extension.
Definitely.
We can take up your matter tomorrow at 10:30. You'll
One correction matter.
Both that matter, that I think that college matter and that matter. College,
don't remember.
So we have fixed at 10:30.
We have fixed one case at 10:30 and we will take up your matter.
Yes, waiting.
All right.
16 with item 48.
16 and 48.
ଅଲଗା ବି କରିଦଉ ନାହାନ୍ତି ଅଳ୍ପ matter ତ ଆସିବ
16. In 48, they have filed the reply that can be taken as the lead case.
ପଳେଇ ଆସିବ ରେକର୍ଡରେ ହେଇପାରିବ ମାନେ we are not ହଁ ଆସୁ ନ କହିଲେ ଆସୁନି
They call that pattern. It's for 2 kilo.
Any other? Okay.
Item number 40.
And in the meanwhile, can you do it one thing? Just prepare a short notes so that when we meet tomorrow, then we can have some brief idea.
Just like a date chart.
See, we have the, in fact, I have the tendency to forget facts.
So, there's no state government is in that.
Item 40. May I please your lordship? My deepest gratitude to the court for accommodating me. I'm deeply grateful.
Yes.
And I'll be extremely short so that your lordship's precious time is saved. Lord, the issue which I wish to place for my lord's kind consideration in a single line is this. We have a mining lease. That lease was for a period of 20 years. I have everything is in a note. I'll just articulate it so that it becomes easy as I develop it. So, this mining lease was for a period of 20 years. 14th August 2001 was the starting period. There is an order of suspension which is being passed by the state government, which according to us curtailed and truncated our period. And under the lease itself, there is a provision, which your lordships had an occasion to consider in 2 other judgments, which I'll take for the context of it, which says if there's a force majeure event stroke some form of prevention, that period can be added back. That period in my case, is about 5 years and 10 months. So short point for my lord's point consideration is, if I'm able to show that the suspension was wrong, then under the mechanism of the lease and the act itself, there is a provision of called adding back. The word is adding back. So in the original period of 20 years, this will get added back if I'm right. Point 2, why did they suspend? They suspended on the basis of a 2008 EC. Fortunately for me, the 2008 EC, it had a condition in it that you should get a FC, which we didn't get. And both the MOEF and the CCF said it. So it's not that I am saying it. I'm going to show that this is basis 2 documents by the ultimate authority, the MOEF, who issues the EC, who said, yes, there was a condition, FC was not issued, it's not sprung to life. The moment that is correct, as it is, and the suspension order falls, we go back to clause 4 of part 9, read with the judgment plot of Parampar, which expressly says if you were obstructed and prevented, then the force majeure provision by analogous principle is triggered And that is also backed up by a statutory provision. So what I'm asking for is inbuilt into the lease and backed by statute, both of which are broadly mirror images. So the matter lies in this extremely short canvas stroke compass. Of course, you will hear long tangential arguments, taking the boat far apart from the shore, but none of that is relevant, which also I will demonstrate in a few minutes before I close. With that, my lords may kindly just take up the flag C. I believe, flag C is where my note is.
Yes.
My lords have flag C?
Yes.
Yes. To start with, I will just show the document in support of what I have just placed for my lord's kind consideration.
Yes.
Please have serial number 3.
Yes.
This is the instrument of lease that I had indicated, which my lords will get at Annexure 6 at 96 at 97.
Yes.
My lords will note the very first line at page 97 says 14th August 2001. So that's the date I mentioned in the list of dates. And at page 98, last but 4 lines, it says, and hereby granted to the lessee from 14th August 2001 for the term of 20 years. So, my lord, this is the 20 year that I mentioned at serial number 3. The next date, my lord, is 22/9/2004, which is the EC, the environmental certificate, my lord. Clearance, sorry. And kindly have page 139, Annexure 7.
Yes.
Yes. My lord, only have to note one clause, capital A, at page 140 under the heading specific condition.
Which annexure?
At 140, there's a heading specific conditions marked as capital A. This is Annexure 7.
Annexure 7. Yes.
Yes. May I place that, Manoj?
Yes.
Yes. 140 under capital A specific condition, the environmental clearance is for 20 years and fresh clearance would be required at the time of renewal of the lease. So, Manoj, 20 years mining lease, 20 years, Manoj, is the EC. Now, Manoj, kindly have the third date in the sequence, which is 29 October 2008. If I may use the word bone of contention, needlessly so. Please turn to, my lord, Annexure 8 at page 159. The relevant part is at 161.
Yes.
My lords will notice again, under the expression specific conditions, capital A, Roman 2, EC subject to grant of forestry clearance. Please see the next one. Environmental clearance is valid up to the year 1314. Working on the mine beyond 14, based on the established reserve, shall be commenced. Now, my lord, this is the key word. Only after obtaining prior clearance from the Ministry of Environment and Forests. Only after. So it's a condition. Now, my lord, straight away, if my lords could turn to page 253. This is Annexure 14. The issuing authority, MOEF itself.
Yes.
Lord, I'm only on this point. This never sprung to life. I'm on that very short point. If my lord kindly has the first para, the last 2 lines.
Yes.
The EC was issued for a production capacity of 15 MTPA. Now, my lord, this is the key word.
subject to the florist clearance.
No,
which is
you are on page
253.
253.
Annexure 14, my lord.
Annexure 14, which
Yes.
paragraph?
Yes, my lord, this is 15.115. Kindly see, it's the MOEF. So the person which grants the EC, first para, last two lines.
Yes.
The EC was issued for production capacity of 15 MTPA subject to the forest clearance. Now, this is the key word, which is yet to be accorded. So, as I indicated in my opening, this 2008 document itself was conditional, and the author of a EC itself says this is yet to be accorded. So, not writ petitioner, not Gopal Jain, this is the ultimate authority. Then 249, if my lord could have annexure 12.
Yes.
My lord, this is the CEC, again, an independent authority set up by the Supreme Court. And my lord will note at para 147, which is at page 249. My lord, all of this is in my note and the submissions which follow, but I'm showing this is as simple, straightforward, and the only issue to be considered. The CC is of the view that the aforesaid clearance dated 29/10/2008 becomes valid only after approval of the Forest Conservation Act.
Where are you reading, Mr. Gopal Jain?
147.
140.
First line. Page 249.
249.
Yes. This is annexure 12.
Yes, 147.
Yes. The CC is of the view that the above environmental clearance dated 29th October 2008 becomes valid. Now kindly note, same words, only after approval under the Forest Conservation Act is granted for diversion of the additional forest line for mining and allied activity. So I have shown the conditional document, the MOEF and CC, all of them, my lord, in one voice have said this 2008 was conditional. That condition never came to be satisfied. It has not, if I may use the word, sprung to life. Now just have straight away the offending page 169.
Annexure.
This is, my lord, annexure 9.
Yes.
Page 169. Annexure 9. So, my lord, I have first set out for my lord's kind convenience my case. Now I am showing what was the impediment, the hurdle which truncated the period. And that is here. It is 31st March 2014. My lord notes the date.
Yes.
Issued, my lord, by the respondent. Now kindly see the subject. Suspension of mining operation. Annexure 9, your lady. Page 169. With reference to the subject, I am to say, that is not on suspension, that the validity of the EC dated 29/10/2008 issued by the MOEF in respect of your block mines expired on 31/3/2014. You are therefore requested to stop all kind of mining activity within the area. So, my lord, straight away, the two pages which I showed, 249 and 253.
Yes.
Which I just showed, that is MOEF and CC itself.
Yes.
And the condition which I had shown, my lords, at page 161. This is in the teeth of that. He proceeds on the basis that it is because of 2008. But 2004 is in play, which I have already shown. So mining lease, 2004 EC, 2008 never sprung to life. Mr. Respondent says, because your EC of 2008 is expired, I am asking you to stop your mining activity. This is in the teeth of the EC of 2008, page 161, MOEF page 253, CC page 249. So this, according to us, false. Yes, your ladyship.
So do you mean to say that you had an EC?
Yes, 2004, which I just showed the court.
Valid till?
Yes, 20 years from 22/9/2004. May I just draw the court's attention?
Please again.
Yes, I had just shown it 140. May I show it again?
Page?
140. Annexure 7.
I just showed it when I placed the 3 dates. Under capital A specific condition, EC is valid for 20 years. Page 140 your edition.
Yes.
The environmental clearance is for 20 years. Your leadership has its first line under specific condition at page 140.
Yes, 20 years.
Right. So
It was issued on?
this is issued on 22/9/2004. It is serial number 4 in my list of dates, date chart. Yes, it's in the date chart, your edition. May I proceed?
Yes. It runs till page 158.
Yes, the full document, yes.
Oh, it's the type copy also.
Yes, correct. 144 this ends, and then from 145 is the type copy.
Consent to operate should be obtained from the SP.
May I proceed, my lord?
This was not conditional. Was
No,
it
not-
conditional?
no.
All this you were supposed to comply thereafter. All right.
So in one line, I have a lease, I had an EC, things were going along merrily, if I may use the word with Christmas around the corner, merrily. Then the suspension came on a completely flawed and erroneous premise, which, if I may say so, I have nailed by showing MOEF, CC, and the EC document itself. If the document of suspension, which I showed at 169 false, the lease itself has an inbuilt mechanism. If the court could kindly turn to page 134, which is the lease in statutory form K, which is annexure 6, clause 4. Yes. Failure on the part of the lessee to fulfill any of the terms and conditions shall not give the central or state government any claim against the lessee or be deemed to a breach insofar as such failure is considered by the government to arise from force measure. Now we'll kindly see how they address the consequence. And if through force measure, the fulfillment by the lessee of any of the terms and conditions of this lease is delayed, the period of such delay shall be added to the fixed period of this lease. So I pause for a minute. It's an inbuilt mechanism that in that 20-year period, the first leg of the race, if there is an impediment or obstruction by which I am prevented from operation of the mining lease, that period will be added back. And there's a direct judgment law interpreting this that if the doctrine of prevention were to apply, you can add it back. So this is the contractual mechanism at 134. In my opening, I had also indicated to the court, my lord, that under the 2016 mineral concession rules, 12 double F, it exactly has the same word, my lord, will be added back. Just take it from me, it's in my note. So I'm showing the foundation is contractual and statutory, but as my lord knows, the lease is issued in form K. It also has statutory flavor. So the argument I'm making is by operation of law, if I am able to satisfy this court that suspension is equal to force majeure is equal to prevention, then that period gets added back. Lord, this is a very important word, added back. I am using from statute and the lease agreement, because you will hear words like extension, renewal, and so on and so forth. None of this is a case of extension, renewal, or any such type. It is a force majeure event you add back. and I'm asking for add back within my 20-year period. So that 20 you add back. That's the mechanism. And my lord knows that the tenure of a lease is a valuable right. If somebody infringes your right, impairs your right, dilutes it, destroys it, the statute and the contract provide for a mechanism of addressing it. I am only coming to the court to say, please endorse what the contract and the statute say if I am able to show that the foundation on which my right was curtailed or truncated is flawed and illegal. It's as simple as that, is my first line. Yes. Now please have in the date sheet serial number 6, 31/3/2014, which I just placed at page 169.
After that.
Hmm?
What did you do after
I had to, no, that's coming. Eventually, the Supreme Court passed an order. I paid 933 crores. They issued a resumption order, and so on and so forth. So that's the second leg. But my case before the court is only on this point. The rest are in the sequence. I'm going to take the court through
this
that.
point after 10 years?
Sorry?
This point after 10 years that
No,
it
no,
has
no.
been illegally
No, no.
suspended?
No. There's a whole sequence. That matter where I had to go to court, and court eventually permitted resumption on payment of 933 crores by a judgment, which I'm going to show you of 2020 Supreme Court. Basis Supreme Court state issued a resumption order.
So, Mr. Jain, the question which is being put.
Yes.
That the order of suspension is of 2014.
Yes.
What are the developments between 2014 and the date when you file the writ application?
Yes. It's all here.
All right. So that is what
yes.
you are putting.
Yes.
Your call of action.
Yes. And I only, if you remember my opening, I was only showing the issue which we are asking the court to consider this. Of course, I'm going to complete the whole sequence. Kindly come back to my date sheet.
Yes.
So your ladyship asked a very relevant question. What happened to the rest of your journey after suspension?
What are you doing for 10 years when you're suspended?
That's exactly on the next page.
And another question.
Yes, please.
Had you challenged that order of suspension?
Yes. I'm going to show you everything. It's right here. Now kindly come back to page 3 of
because
the
Mr. Jain, we should be clear.
Yes.
That only if we find a circumstance that the order of suspension requires interference, then only you may have a case.
Absolutely.
Otherwise, you can't have any case.
I'm grateful. I also
yes, including that if we are not satisfied, if you are not able to explain satisfactorily the delay, then also it will be difficult for us to interfere.
Be rest assured, I'm going to complete the narrative and the journey.
All right, please come.
Yes, I was only on the first leg of the journey, showing this is the issue. Now we have to complete the journey and show what happened.
Yes.
So, my lord, please have. Now, my lord, at the end of the second page is the 31/3/2014, which I have shown, right? Now, what happened? And what a heavy price I paid because of this mistake, you will see starting the next page. Page 3 of my date sheet, serial number 7. My lord has it?
Yes.
Your ladyship has 25/4/2014. After suspension on 31/3/2014, the Central Empowered Committee filed a report in the Supreme Court where the petitioner's mine was included at serial number 9. 16/5/2014, in view of the wrongful suspension by the opposite party, the petitioner's mine got added in the list of 102 mines by the CEC. In view thereof, the Supreme Court suspended the mining lease of the petitioner and 102 mining leases. The Supreme Court gave liberty to the lessees to approach it for modification of the order. So first point, which the court may note, because of the wrongful suspension, CEC puts me in a list. Supreme Court then passes an order of 16/5/2014. So suspension now is under an order of the Supreme Court by virtue of this erroneous suspension order of the respondent. Now, what do I do as the court asked me? Serial number 9 of the date sheet. 16th August 2014 and 21st August 2014. The petitioner addressed 2 letters of 16th August 2014 and 21st August 2014 to the opposite party, seeking permission to resume mining operation in terms of the 2004 EC, which was the in-play EC, which was valid and subsisting for 20 years. I'll take my note to the document later. I'll complete the sequence to address the court's query straight away. 15/1/2015. MOEF accepted that in terms of the conditions of the 2004 EC, the EC is valid for a period of 20 years. Further, the 2008 EC, which was subject to FC, was yet to be accorded. Permission to resume mining operation was thereby approved subject to permission from the Supreme Court.
So if you had an EC of 2004 for 10 years.
20 years.
20 years?
Yes.
Then why did you again apply for EC in 2008?
Yes. There was expansion at that time, but that EC came with a condition and that condition was never met. So it never triggered to life. It remained dormant and inoperative. That's the whole point. But when you want to
increase your capacity
yes,
for
exactly.
that
Yes,
EC.
correct. Exactly. But it was conditional, as I already showed, and we can revisit it. If I just complete this sequence, it will address the second query which fell from your ladyship. So I'll just complete this and come back to it. Now, kindly see after the MOF says subject to Supreme Court, please have serial number 11, 27/1/2015. The petitioner then moved an application in the Supreme Court seeking resumption of mining operation. 29/1/2015, that is serial number 12. The petitioner received a response to its letter from the opposite party expressing its inability to allowing mining operation in view of, and they go back to the interim order of Supreme Court of 16/5/2014. Now kindly have the next innings, if I may put it, 5/12/2019, serial number 13. The petitioner again moved an application before the Supreme Court seeking resumption of mining operation. And finally, there was some joy, some resumption order. 15/1/2020.
Just
An application after 4 years.
Your Ladyship, I had already moved the application earlier, which I just showed. When the Supreme Court did it, we addressed 2 letters, went to MOAF and then moved. Because the Supreme Court had set up both CEC and MOAF. So if you see, after serial number 8, 16/5/2014, kindly have August 14 and 21st August 14. MOF accepted and serial number 11, my first IA. I've styled it also for your ladyship's kind consideration. 27/1/2015, petitioner moved an application for resumption of mining operation.
Moved is filed or moved or
No.
filed?
Filed. But the context in those days, because we were in the Supreme Court, was and your ladyship also knows, all the states by and large were being looked at by the Supreme Court. So it was not A versus B, it was the omnibus thing. Karnataka, Orissa, Goa, so and so. That's why I've styled serial number 13. When I came to 2019, your ladyship, it's the second one in sequence. The petitioner again moved the application before the Supreme Court seeking resumption. For grant of the petitioner's prayer for resumption of mining operations upon the petitioner depositing 933 crores assessed by the CC in its final report on the basis of the 2004 EC. Accordingly, the Supreme Court directed the petitioner to pay 933 crores. The Supreme Court then directed resumption of mining operations, acknowledging the validity of the 2004 EC and the 15 January 2015 letter of MOEF explicitly authorizing continuation of mining activities on the existing 2004. Now,
but why were you directed to pay this amount?
Yes, not be paid that amount immediately.
So why ask this?
What was the
Because
reason?
the CEC in its report had said that we need to pay these dues.
Why?
What are those dues?
Yes, but not excess production in that period.
That means in the absence of EC for that,
The CEC said there was excess production. court says if you pay 933
Exactly, so that
Yes.
is excessive production and violation of the DC probably.
Yes,
This
correct.
was for a particular quantity you have, okay.
Correct.
So
So
that was the case of illegal mining.
excess mining
All right.
beyond the capacity. Two sides of the same coin, but just whatever. But ultimately the good thing is the Supreme Court says, all right, pay a price for it, but you can resume mining. And I actually resume mining, which I will show you. So if I may use the Hindi word. Paap dhul gaye, ab aage badho. So at least we got a
Very difficult.
lease applied,
Yes.
but at a very high
Still-
price of 9.
Still, let us see.
930.
Let us see.
Oh, sorry. Apparently, the reason is want of EC. So whatever be that,
What of EC, but you said you had a EC all through.
I'm giving the
reason.
CEC's reason.
Okay.
So I can't improve on it. I'm only saying, according to me, the EC itself was for 20 years, which I showed you. This is what the government's view was, that due to want of EC. So sometimes they say 4, sometimes they say 8, sometimes they say want of EC. But short point is, it came at a price, but most important line here, state and CC have no objection. So I am now resumed mining under.
So there are two aspects. One, on the basis of 2004 EC.
Yes.
Therefore, your EC was of 2004.
Yes, correct.
That was valid.
Yes.
And the state government agreed.
Correct. Absolutely.
Yes.
And, that is to be found at page 291 in para 4,
Yes.
which is annexure 18. Yes, correct. This is not, as I indicated, the common cause matter. So it's not A versus B. It's everyone is at play and under consideration. Common cause was the umbrella under which they considered various states, including Orissa. And we are also one who's come in for consideration here. Page 291.
Yes.
In the light of these observations, the Supreme Court appointed a committee. Committee found I had not violated either Section 6 or Rule 37. SMPL, that is the same petitioner as before your lordships, is suffering irreparable injury and highlights it has lost more than 5.5 years now. Hardly a year of its lease period is left. Expressing.
You are reading which paragraph?
Para 4 at page 291.
Para 4, yes.
This is your submission, not the finding of the Supreme Court. Otherwise, they would not have imposed cost.
You,
Yes, we go.
yeah, I'm just reading for completeness. The direction is in the next para. Expressing willingness to furnish the
Please, sorry, Mr. Gopal Jain. This is page 291.
Please, my lord. Para 4.
Paragraph 4. In the light of these
In the
observations.
light of these observations, that is not a report of a committee appointed by the Supreme Court of 2 retired judges that I have not violated Section 6 or Rule 37. The petitioner contends it's suffering irreparable injury and highlights how it has already lost more than 5.5 years. Hardly half a year of the lease is left. Expressing willingness to furnish an undertaking or bank guarantee equivalent to dues as assessed by the CC, the applicant seeks permission to resume mining operation. Upon notice, the Council for the State of Odisha and CC expressed no objection against granting the prayer for resumption, subject to depositing the CC assessed dues and strictly complying with all other rules, regulations, and conditions for conducting mining operation. Now comes the order. In view of the above, the application is allowed in the following terms. 1. SMPL is granted 1 month's time to deposit the dues as assessed by the CC in its report of 8/5/2019. In addition, it will file an undertaking to comply with all rules, regulations, and provisions for carrying out the mining operation. And 5.3 is what I was saying. After complying with the direction, the SMPL, that is the petitioner, can resume its mining operation in the leased area for the remainder period of its lease. So Supreme Court, upon payment of 933 crore, permitted resumption of mining operations under this order of 15 January 2020. I deposited this amount on 28 January 2020, which is serial number 15 of my date sheet. And now please have the resumption order passed by the government.
Well, this 5.3 is also very important.
Please, ma'am.
Maybe for you and maybe for the state also.
Please,
I
ma'am.
don't know.
Yes.
That will depend on how do we interpret the provisions.
Please, ma'am.
Says 5.3 can resume its mining operation
Please, ma'am.
in the leased area
Correct.
for the remainder period of its lease
Please,
period.
ma'am. Absolutely.
So according to you,
Yes.
during the period,
Yes.
the order of suspension was operating.
Yes.
That was also remainder.
Yes.
This must be your
Yes.
case. If you fail here, then you
That's it,
fail.
exactly. I started at the very opening to show precisely that the same 5.5 years which is noted there in our submission. If we are right, the suspension is wrong, as my lord rightly put it to me. You have to get over the hurdle of showing the suspension is wrong. If the suspension is wrong, then clause 4, part 9 of the mining lease, read with 12 double F, kicks into play. This period gets added to my period of lease. That's the short point I'm canvassing for the court's kind consideration. I am not asking for extension or renewal of my lease, which is a term of art under this act. We are not going down that path. That's not my case.
All right.
I made it clear at the offset, and I showed the pleadings also. Now kindly have, my lord, as a consequence of the Supreme Court order, on 30th January 2020, the government passed an order, my lord, permitting me to resume operation, which is Annexure 19 at page 295.
31.
Yes, 31st January 2020. May I, with my lord's permission?
Yes.
With reference to the letter subject above, I am to say that as per the Supreme Court order and as per the instruction of the Director of Mines, dated 31st January 2020, my lord, this is the key word, you are hereby allowed to resume mining operation in respect of your mining block within the granted area and approved forest area, subject to possessing all other valid statutory clearances. So this is a validation as a consequence of the Supreme Court order, where a resumption order is passed. So 31/3/2014 comes to an end on 31/1/2020. Put in a nutshell. Now just make a note of 3 very important sequence of dates here. The lease period, this is important note for the submission which I'm making. The lease period.
Just
The next serial 17.
Yes, your ladyship.
There's a matter before the Honorable Supreme Court. So these are the things you were mentioning, or there are some other matters.
Which
Following the suspension letter.
You are referring to which item? Which item of your?
Serial 17.
You are
No,
referring to
he
serial.
was going, but it's got my attention.
Your ladyship, the story ends on resumption at serial number 16.
This is thereafter. Okay.
Yeah, on this issue, on the issue which is the subject matter of the writ, I sent a representation. I'll come to that just
Okay.
in a bit.
So on 31/1/2020, you resume
Yes.
mining operation.
Yes. Yes.
After 4 years, you sent a representation.
Yes, the representation was sent on
All right.
28 June 2020. Correct. Now kindly note 3 dates. Very important. No? If my lord could kindly just note this down. Yeah. First page. Lord, kindly come to my first page for a minute.
Yes.
Lord, please just note the last one. This is just the sequence of date, which is very important. Lease deed is 14th August 2001 to 13th August 2021. Correct? I've shown that the lease document itself, which was at serial number 3. Right? Then I operated from 14th August 2001 till 31st March 2014. Because the suspension happened on 31/3/2014. All these documents I've showed the court. Then, my lord, from 1st April 2014 till the resumption order of 31st January 2020, I was not able to mine. Is my 5 years, 10 months, which is my writ petition before the court. And post the resumption order, I operated for a period of 1 year and 3 months, which is from 1st February 2020 to
No, but was this also not because of
Yes.
the Supreme Court's order?
Yes.
Your suspension
Yes.
was not only because of the order of suspension passed by the state government, but also in the light of.
I'm very grateful, my lord. And fortunately for us, in my note and the submission is this. May I answer that statement? I'm very grateful. My lord, the root cause, if I may use the word, is the suspension order because the CC acting on this suspension order files a report in the Supreme Court, and on that report, Supreme Court, my lord, passes that interim order of 16th of May. So the root cause, it emanates from it.
No, maybe the root cause.
Yes.
But because of that,
Yes.
the Supreme Court passed an order.
Yes, correct.
Suspending your.
Yes, correct.
So if we pass an order otherwise.
Yes.
we-
In 2014, the bone of contention, serial number 6.
Yes.
Now please have serial number 7.
Yeah.
The CC basis this, my lord, as I've indicated here. My lord has this. CC, after suspension, the CC filed a report before the Supreme Court where petitioner's mine was included at serial number 9 of Annex 2 of the report. Right, my lord? That is to be found at page 184. So let's link this. First come suspension order.
No, we are on this interim order of the Supreme Court.
I'm just showing the link. 31(3) suspension order. Basis the suspension order, the CC files this report, and at page 184, my lord will take it from me. My name is included. Why is it included? It's because of the suspension order. So there is no separate indication application of mine.
No, because in your short notes you have mentioned.
Yes, ma'am.
That the Supreme, in view thereof, the Supreme Court in WPC number suspended the mining
Yes,
lease
correct.
of the petitioner.
I'm straight on the query that your lordships have put to me, but I'm saying the context is important. Supreme Court did not say I ban you for A or B. They did it because they acted on the CC report. CC only took what the state government had done and put me at serial number 9 of the list. So first,
So we can say same thing in a similar in a different way.
Yes.
That because of
Yes.
a wrong order of suspension.
Yes.
The Supreme Court passed a wrong order.
But I'll put it like this. They passed an interim order by which they put an embargo on mining. Yes. On a lighter note, of course. No, on a lighter note, we all agree. But just as they say,
So which according to you is correct or wrong?
they vacated it finally in January 2020. So best way of answering it, I can't say court order is right or wrong. I'm answering it in terms of the court order which allowed.
You are saying that the background in which
Yes,
the Supreme Court had passed the order, the basis on which the Supreme Court had passed the order, and the circumstance in which the Supreme Court directed for resumption.
And my lord, secondly, I'm very grateful. My lord then said, would it in any way be changing the Supreme Court order? Answer is a clear no. Why? Because the same court which passed the interim order, and that was only interim. Yes, Major, a judicial interdict, but it's gone. But the most important thing is it has gone. And in that, I'm very grateful for the query. In that, the state government says, I consent to that order. This is equally important. The same.
That's okay, disputing.
Yes, no, I'm only answering my lords because I must satisfy the conscience of the court.
No, we should be clear.
Yes, absolutely. And it's a very important question. And as officer of the court, I must satisfy my lords that any order which my lords may pass in the writ petition is not inconsistent with any other order, in particular of the Supreme Court. That's my duty to satisfy the court. So I'm showing 3 things. Surrounding circumstances, background, source, step 1. Step 2, interim order. But the same interim order is vacated by the same court with an express order of resumption. And 3,
expired in 2021.
Yes,
Thereafter, you stopped mining operations.
yes. If you see the first sheet,
So that's what you told, 20 years
28/5/21, I stopped.
stopped. So thereafter, 3 years you waited, and thereafter 2024 you asked for.
You know, multiple litigations were going on, etc. So short point is and everywhere I put reserve my right for this. Kindly just see my trauma from 2014 for 7 years. We've gone through litigation from multiple fronts. So idea is, am I seeking a remedy which is entitled under the contract and the law, which is what a equity, court of equity and the writ court always molds the relief to meet the ends of justice in the conspectus of the case. So for no fault of mine, I've already paid a price. All that I'm now saying is, if there's a mechanism to address it, I'm requesting the court to consider this as my request in terms of contract and law and issue an appropriate order if I'm right.
Okay.
Now, my lord said, show me that the suspension order is wrong. So kindly now in this slide, please come back.
Now the question has become more difficult because
Yes.
even if we reach a conclusion
Yes,
that the order of suspension was incorrect,
yes,
it had the seal of the Supreme Court by way of interim order, of course. Because of that, you could not
but
carry out the mining. And we don't know. We will have to examine the statutory provisions also.
yes, madam.
Like when the Supreme Court says a remaining period,
Yes.
remaining period under the law would add that period also, may add that
No,
period also.
no, my lord, with greatest of respect. Before the Supreme Court, what the Supreme Court?
No, that was not the issue.
Yes,
That was not the issue. That was not adjudicated upon.
yes, I'm great.
Had that been adjudicated
Yes,
upon,
I
the
would-
matter would have been different.
Yes, absolutely, correct.
Right. Therefore, when the Supreme Court says remaining period,
Yes.
means the remaining period for which you had a right to
Correct.
under the law and the agreement.
Yes, and my lord, may I just divide it into two parts? My lords are absolutely right. When the Supreme Court says resumption of mining for the remainder period, it is that 20-year lease period which is granted under the lease. So absolutely right. They say you continue for the remainder period, whatever is the life of that lease. Force measure and add back is not furtherance, extension, or renewal of that final outer limit. The legislature was very clear. They used the word add back. So forget this case. Let's take a simple case. When we say force measure, generally, it means a certain event came, it interdicted or stopped something, it puts things in a freeze, in an abeyance. Then that event gets lifted. That's how a force measure gets lifted. That, therefore, is a loss because of ABC reason, which is a doctrine of prevention, which a direct judgment, which I'm going to cite, shows. Therefore, the lease envisages the situation that if there is something lost because of that, I'm just using simple words and not the technical word, then it can be added back. Added back is different from extension and renewal. That's why the expression, each word has to be given its meaning in the context. That's why it comes under Part 9, Clause 4. It doesn't come under the word term. Otherwise, they were obviously conscious of the fact, and you could have used in that heading and saying whatever happens, not exceeding the term. There is no such prohibition. Therefore, this is the inbuilt mechanism, and the mineral concession rules has an identical provision. So I'm showing the law also has it and the contract has it, and the contract under Form K is a statutory lease in that sense, or at least it has statutory flavor. So the basis is on a much stronger footing, and my lord, the term of a lease is valuable. Now, just let's go back in time for a minute. Supposing the 2008 EC which the MOEF says was conditional, never came into play, I would have merrily gone along. So this 5 year, 10 months would have inured in my benefit. Question is, who deprived me of 5 year, 10 months? In a writ, my lords, you're only going to examine what is the injury caused and by whom.
Your submission is akin to, in fact, the submission which you had made on the last occasion,
Yes.
that you will take 30 minutes.
Yeah.
So because we consume 20 minutes, then that period will have to be added back. Okay.
But this is a very warranted, welcome intervention. Because as my lord rightly said, it's a question of clarity. And I must, my lord, satisfy that. And you will add back this time, whatever came from the court, my lord, will be added back to my 30. So, my lord, kindly come back now to the 169 force measure.
Yes.
My lord, 169. Annexure 9.
Yes.
I'll slightly present it in a different light now that we see. So, my lord, kindly have 169. Please see the subject suspension of mining operation. Who's the culprit? According to me, the respondent, right? It's the respondent who issues this. Now, please see. With reference, I am to say that the validity of the EC of 2008 has expired. So, my lord, this is flawed in the teeth of a statutory environmental clearance, and the MOEF itself at page 253 said this is yet to be accorded. So this is flawed at the inception, at the very root. What my lords are testing is, if this had not been there, would the petitioner have enjoyed 5 years, 10 months? Answer is an unequivocal yes. That's all my lords are testing. That for clause 4 to come into play, I have to show a prevention. I am saying this was the prevention. This is the starting point. Number 1. And now please see 253. And my lord will always attach weight and premium to what the author says, which is to be found at 253. Annexure 14. First para, last 2 lines. I'm only showing what is relevant, Lord, so that page 253, Annexure 14.
Yes.
So, my lord, if you can kindly come back to 169, his whole basis that it expired is belied by the author who issues the statutory environment clearance. It's flawed at the inception. It's void ab initio, and something which is void goes completely wrong. Second, what was the consequence and effect of this? The consequence and effect of this is I was deprived of the full tenure of my lease. Number 3, how is it to be addressed? That is addressed in clause 4, read with the statutory rules. Now, please have the rules itself, my lord. Rule 12 of the Mineral Concession Rules 2016.
Which rule?
My lord, kindly have Rule 12 first. 2016 Mineral Concession Rules. My lord said, place the statutory scheme. I am now showing the statutory scheme.
Yes.
Lord, kindly see 12, terms and conditions of a mining lease. My lord sees that?
Yes.
Very important. Terms and conditions of a mining lease. Every mining lease shall be subject to the following condition. Now,
Yes.
please have double F.
Yes.
May I?
Double check.
Does my lord have the universal book?
Yes, we.
Yes, then it's 472.
After that. After the.
Lord, is it? Any? Yes. My lord has double F.
Just a minute.
Just a
Sorry,
moment.
sorry.
Yes.
Now, my lord, please see the same language which I just showed my lord. Same language. But we have given the new books as well. But I have just for my lord's convenience
Yes.
marked it. And my lord will see on account of the force majeure event, the period of such delay shall be added to the period fixed by the rules or the mining lease. So it is automatic by operation of law. If I'm able to show that I was prevented, it is operation of law. The case that I have before the court is based on this. Kindly see the language is very clear. Shall be added to the period fixed by these rules or the mining lease. So whatever is the period fixed, it will be added to it.
Yes.
So, my lord, they are very, very clear that if something comes in the way, it should not deprive you of your valuable right, which is the term stroke tenure. So, I placed great emphasis on shall, added, and period fixed.
Yes.
And this is similar to, my lord, clause 4, part 9, which my lords have already marked at page 135, 134, 135. Annexure 6. And that also has the word, my lord, which the lessee Now, I'm going to kindly come back to 135.4 of the paper book, which is the lease. So I've shown the language used here, which says shall be added to the period fixed by the mining lease.
Yes.
By the mining lease.
You are reading what?
Yes, I'm now taking my lords back to the lease, mining lease, in juxtaposition to the words used in the rules. If my lord comes back to page 134, clause F, sorry, clause 4 of part 9. May I?
Just a minute.
Sorry.
Yes.
Kindly have, my lord, the last 3 lines. (135), last 2 lines, which the lessee could not reasonably prevent or control, on which I'm going to cite a direct judgment, my lord, exactly on this word. So in another word, it means kindly exclude this period of suspension or add this back. I hope, Lord, I made myself clear. This is to be excluded or put another way, added back. Now, please have a direct judgment. of the Delhi High Court precisely on this issue, which is in a compilation of judgments, Dharamveer versus Union of India.
Yes. Yes.
My lord has it. Please see the cost title, my lord. Dharamveer versus Union of India. Division Bench of Delhi High Court.
Yes.
And here a lease was prematurely terminated. Now, my lord, straight away come to para 40, 42 at page 86. Oh, sorry, my lord, it will be 35 in the compilation.
Yes.
Sorry, I was reading from my printed copy. My apologies. My lord, please have para 42. Or may I just start from 41 actually? May I?
Yes.
The lease deed provides in part 8 that the lease will hold and enjoy the rights quietly after paying the rent and performing covenants and agreements during the term of the lease without any, very important word, unlawful interruption from or by the state government. So 31(3)(14) I will show is nothing but an unlawful interruption. The provisions pertaining to the rule of force majeure are indicative of the fact that the period of interruption can be excluded from the term period of the lease. Exactly what my lords put to me. Clause 4 provides that to fulfill any of the terms and conditions shall not give the central or state government any claim against the lessee or be deemed to a breach in so far as and last night such delay shall be added to the period fixed by this lease. My lord, same clause 4 which my lord saw in the paper book. Now kindly see 43. The expression force majeure has been held to be so and so, so and so, so and so, so and so, and any other happening which the lessee could not reasonably prevent or control, though it is not a case of force majeure in terms on analogous principle, it appears to us that the unlawful interruption of enjoyment caused to the lessee by the illegal act of the respondent is something that the lessee could not reasonably prevent or control, and the period of this interruption should be excluded from the term of the lease. It appears to us necessary as a matter of law and justice to give this consequential relief as a result of our order striking down the premature termination. Kindly see the next one. Not to do so would result in multiplication of litigation and depriving the petitioner who has been prejudiced of substantial relief. Now, my lord, please see argument of the learned advocate general. My lord, it's almost prescient, isn't it? It is playing out after all these years, similar to what you will hear. Cannot be extended, my lord, and he rejects that submission. So, short point, my lord, your lordship will note that any form of unlawful intervention which takes away a valuable right from the tenure of my lease can be added back, and that period of suspension in my case will stand excluded, flowing from 12 FF read with clause 4. Statutory, by operation of law, automatic. Now, my lord, kindly also have, please have the next judgment, Avtar Singh versus Union of India.
Yes.
Now, this starts at page 38.
Yes.
You know, this is also a mining case where there was the cancellation of the lease. Now, my lord, kindly have para 75 at page 60. It's if I may, on a light-hearted note, say almost as if these two judgments have written a script for my lord's kind consideration. Para 75.
Yes.
My lord, the first 4 lines is writ allows into from the suspension letter and simply took my name from the list of the suspension order and in their report put me at serial number 9. Basis that the Supreme Court passed an order of injunction. So first point I'm saying, please see the context. The genesis is this. Per contra, if a court said you so-and-so have violated the condition of lease, I put an order of embargo, my lord would be right. The cause of action is a Supreme Court order. Can you now come back and say this would be separate? Answer here is no. There's a causal link directly connected. Basis is this point. Second, 16/5/2014 came to be vacated. In fact, a positive order was given on 15/1/2020. Normally, courts pass an order removing a fetter. In this case, they pass the express order, you can resume. Part 3, the same blameworthy party, as I style it, agreed in the Supreme Court that resumption of mining is to be done and passed an order of resumption on 31st January 2020. So it is as if to say
2020 based on EC 2014.
Four, sorry. Exactly. That's my point, Parod. That 2004 is now accepted across the board as the only EC. If that is it, the 2008 is palpably wrong. So it is striking, it's in the face. Lastly, just to satisfy my lord's conscience, when this final judgment is passed, as my lord knows, all interim orders stand vacated and gone. This will relate back to that day. So at the end of the day, we are not coming in the way of the Supreme Court. Supreme Court allowed me resumption of mining. What I'm seeking is adding back, which the two judgments have clearly said, is adding back to the 20-year period. So I'm saying within my 20-year period, what was wrongfully excluded by virtue of an unlawful intervention should be added back, which is the language of the statute, because that's exactly what the Act, the rules, and the contract rightly say, which the second judgment says, your lordship can grant a mandamus, direct them to extend that period by adding back 5 years and 10 months, which flow from this unlawful intervention, Lord, is the case. That would also meet the ends of justice, because you have made, if on the face of it, I may use the word, a latent, humongous Himalayan error. I have borne the burden and the cross of it, Lord, for this period. But if I have a remedy in law which entitles me to add back, and I come to the court and give material to show that that is wrong on the face of it, MOEF and CEC, highest two authorities on that issue, more than the state government, because it's on the EC, he says it never sprung to life. And my lord, in simple English, there was a condition, which I showed my lord at page 161. He only had to see that condition. So wheel turns full cycle, and we are back. So my prayers, my lord, if my lord now has my writ petition at page 33.
Yes.
Prayer A, my lord, add the 5 years and 10 months lost because of this. So that is similar to the two judgments, and my lord, the second judgment grants that relief. So that, my lord, is my positive case for my lord's kind consideration. Now, my lord, if my lord kindly has the counter affidavit which they filed, on 30th September 2024. Yes. Now, my lord, please have page 15.
Yes.
Para 9. That's why, my lord, I was emphasizing on the word add back, add back, add back. Sorry to sound like a stuck tape recorder, but now your lordship will see why.
Yes.
Page 15, para 9. It is humbly submitted that in view of the amendment to the MMDR Act in 2015 and substitution of Section 8 and insertion of new 8A, concept of renewal and extension has been done away with. So first point, my lord, I am not for renewal, I am not for extension. So his entire defense, or in large measure, my lord, is attributed to the fact that this is extension stroke renewal, which I have said in categoric terms, it is not. In fact, ground Q at page 28 of my writ expressly says add back this period within the original term of 20 years, just for my lord. So this doesn't apply. Now, my lord, please have page 24. Sorry, not 24. Page 80, 81. He relies, my lord,
81 of
this very year.
81. Wrong counter affidavit.
My lord, he attached this. Two judgments of my lords.
Which page?
My lord, page 81. No, same. I mean the counter affidavit itself.
Counter
Yes,
affidavit.
my lord, there are two judgments of this court. He's relying on those judgments.
Yes.
So I'm only showing, my lord. Yes. My lord has page 81.
Yes.
You know, kindly have para 27. It would be pertinent to notice that admittedly, the supplementary lease deed was executed on 30th March. Under an order passed by the director of mine, the lessee was allowed to resume mining operation from 5/11/15. The original lessee, without any demur, accepted the term of the lease, which not only mentioned the date so and so, up to which the validity period of the lease was being executed, but it contained a specific reason as to why extension was being granted up to 2024 with reference to Section 8A. The lessee continued its mining operation on the strength of the supplementary lease deed without raising any objection, knowing fully well that the validity period was up to 20th of February 2024. Now please have para 29 on the next page, 82. The lessee, in our considered opinion, cannot be permitted to raise the grievance now after having specifically agreed to the validity of the period of the lease up to 20th of February 2024. So, my lord, this was fact-centric, that you signed a supplementary agreement and you expressly agreed to a cutoff date of 20th February 2024. There is no such supplementary agreement. I have nowhere agreed. In fact, my list of dates is shown. From the time of the suspension order, I continued request to the respondent to please allow me resumption of mining operation. So it's exactly opposite. So this judgment, with great respect and humility, my lord, does not apply. Likewise, my lord, there is another judgment also he's relied on. Both these judgments, my lord, essentially turn on the fact that there was a supplementary agreement and the party there had agreed without demo. That is at page 43 to 58, my lord.
And what is this judgment? Supreme Court's order?
So he is only showing that your lordship's judgment, I think the SCP was dismissed. I was withdrawn. I have no quarrel, my lord, with either of the thing. I'm saying it doesn't apply because the fact situation was entirely different.
Yes.
And my lord, para 29, I've just shown that. So my lord had consciously noted supplementary agreement, acquiescence.
So that was that decision was in a different context.
Yes, exactly.
Because of the amendment.
Yes.
Press agreements were
Exactly.
and therefore and in that supplementary agreement some date was fixed.
Exactly. My lord, I'm only doing because I started at the beginning that while I try and focus and shoot at the arrow straight, everything that you will see here is based on a non-issue, which is not the issue here. It is not relevant or germane to address the case which I made out. So I'm only showing this so that before I end, my lord broadly knows that his whole pitch is on that 8A and these two judgments, which are entirely different. The context is different. I'm not going down that path at all. So I just wanted to, my lord, satisfy my lord that that is not my case. So no point answering a case which is not the case for considering. Is only again, my lord, a distraction doesn't take us any further. Short point, and I end with this. I appeal to the court, my lord. Please apply clause 4 read with 12 effect in the light of the two judgments of the court. I'm only asking for justice to be done. I have already, my lord, suffered for the law. I'm extremely grateful.
Thank you.
Yes.
Yes, Mr. Acharya.
Yes.
Sorry for exceeding the 50
No.
minutes. So
You,
some may be added back.
yes, that has been done.
Next time I'll curtail myself. So
Yes, Mr. Acharya.
May please, Lordship. Let the ball which my learned friend tries to roll now in the playground, I did the same mistake and your Lordship may not put me through in JDL binds. I'll come to that. Before that, first of all, let me address your Lordship on two aspects apart from the statutory provision as amended in 2015. But your Lordship have to judge the conduct of a party. I'm just passing and that has been suppressed. And on that score alone.
Just a minute. We had a question.
Yes.
We had a question just from Mr. Jain.
yes, ma'am.
In 2020,
Yes.
a decision was taken for resumption.
Yes.
So what made you think that you should claim this, the benefit under clause 4 and 12FF
Yes.
in 2024?
Yes.
Because between 20 and 2024, for the first time,
Yes.
you, so what was the cause of action then?
Yes. Not in an earlier round of petition.
Sorry, Mr. Acharya, just a minute.
We were not in a first straight answer to my lords. We were in the battlefield of litigation. So the Mahabharata was being fought. After the Mahabharata was fought, in a writ petition which I filed, I expressly reserved my rights, my lords, to seek this in a separate proceeding. So if I may use the word litigation fatigue also sets in, and obviously they've come for advice and we have given, both of us have given this advice. So you can blame us for giving this advice. But expressly, my lord, this right was reserved in the earlier petition. As I said, we were in multiple stages of litigation. So first we had to clear the air, start our resumption, and as I've showed, my lord, it's been a 10-year saga. We, my lord, as I showed.
So can you say
Yes.
that it ought to have been automatically done? Like if
Yes.
the period was for 20 years.
Yes.
And then a decision was taken for resumption, then that period.
Not, if I may put it this way, that is of course a course of action, my lord. But given the state of, if I may say so, we were.
No, are they required to do? This is what we want to know.
Yes.
Are they required to do, or you were required to make an application? And if you were required to make an application, then why did you do it after?
I was with great respects not required to make application. My submission for my lord's consideration was it's by operation of law. I read the rules shall be added back to the period fixed. Right?
You are right.
Yes.
But then you will have to tell them that it was because of this circumstance.
Yes.
That you could not do it.
Correct.
And therefore it should be added back.
Yes.
And therefore, it is not something automatic which ought to have happened. You had to approach,
Yeah.
you had to
Prompt.
convince.
Let's put it like this, had to prompt or
No,
at
no,
least
no
act as a
prompt,
catalyst.
no prompt. Force measure is something
Yes,
which you have to demonstrate and establish.
yes, correct.
So, and therefore we want to know,
Kindly
That-
take it,
and
kindly take it
yes.
like this. The fact that we are still in a seriously adversarial mode, this would have been, if I may use the word with all respect, a mere empty formality. I am before a court of justice. My lord will always take the context and take a holistic approach to see, will I be curing a miscarriage of justice which has been meted out to the petitioner by the contesting party? And the hands of the writ court are always, my lord, flexible to mold the relief to an exigency of a situation. So I'm saying there's extraordinary power. I immediately take my lord's point that could you have been a smart aleck and rushed faster like a 100-meter sprinter? Perhaps the answer is yes. But my lord, honestly, if my lord has seen, I've really been through a lot in this whole process. So it was something to pay 933 and get resumption of mining. And the answer could have been, of course, with hindsight, you could have done it there and then. But my lord, it's not that I didn't reserve my right. I did reserve my right and I've come to the court. And I'm only appealing to the court, my lord. It's ultimately a sense of justice which you get at the hands of a writ court.
all right. Yes. Yes, Mr. Acharya.
Not going to the factual aspects of the timing. On question of law, let me advise whether such a petition can be entertained at all. Let the petitioner has been litigating, my lord, since 1964, my lord, since the date of grant of pledge. That the statute you well aware came to be amended in 2015. That the contention which my learned friend will not resist, that he should be compensated for that period of 5 years, whatever may be the reasoning. That has already been answered by your lordship in JDL mind, relying upon two earlier judgments of this court, Lord R.P. Sao, which Lord went up to Honorable Apex Court in appeal and was rejected. And your lordship's judgment was also carried to the Honorable Apex Court and that was also dismissed. That in the very same petitioner's case that has been suppressed, of course, in this petition that is pending in Supreme Court, he was claiming 10 years Miller period. Your lordship may kindly look at that judgment. I was surprised. It is not a part of the counter. That you will say, I'm passing on the two judgments. That has not even been mentioned in the cost guide. But on these four alone, this is the petition which should be dismissed with exemplary cost for abusing the process of the court. Your lordship may kindly look at the same finding, Miller, that has been dealt with already. The CC's report, illegal mining, Saha Commission report, payment of 900 some odd crore towards the penalty, illegal mining. Your lordship may kindly this WPC number 17905 of 21, which has been dismissed. The self-same prayer was made for adding another 10 years period. Here, Milady says 5 years, 10, there it was for 10 years. Your lordship may kindly turn to the factual matrix of those cases which have been dealt with in Paraj 3, 4, and 5. But I'm not surprised how this could be suppressed in, yes. In the Milad, I'm coming, I'm answering. The prayer Milad in WPC number 6905 of 2021 is for quashing of a demand issued by the Joint Director of Mines opposite party number 1 in the writ petition, directing the kindly don't directed to pay a sum of rupees 2045 crore. The day he was granted permission, he started illegal mining. And the demand, that was in January 20, the demand came in 21 for violation in January and February. That was, that has been to notice demand issued by the JDM, asking SNPL not to cross the pro rata limit of production against the quantity stipulated in the environmental clearance accorded by the Ministry of Environment and Forest, Government of India, and in case the said limit is already reached, to stop production immediately to quash a letter
dated so and so was informed by the JDM, Joint Director Mines Miller. That is on verification from the 13 MS login, it was found that SMPL has already achieved production of so and so, thus crossing the pro rata limit of production, and therefore SMPL was asked to stop production of iron ore in the mines immediately. In the third writ petition, this writ petition, the prayer was for granting another 10 years beyond the expiry period of August 2021. Petitioner number 1 and its director shareholder petitioner number 2 have challenged an order issued by the DSM government of retrospectively revising the date of renewal of lease deed which was executed on 14th August 2001 to 1st August 1964. Your Lordship knows as per amended section 8A, it cannot be beyond the statutory period of 50 years. 31/3/20 is the date on which it has to put to the auction regime. I'm coming to that, Milord. Background facts. Your Lordship may not look at this. Your Lordship may now come to para. There is not a whisper, Milord, about this. Yes. Common cause, everything has been, Milord. I am taking one by one, Your Lordship. Lord, Your Lordship may kindly come to para.
Yes.
Para 37 C's reports. Lord, admittedly, there was no statutory clearance beyond 31st March 2014. That has been recorded in this judgment. Para 36. The mining, para 36. On 31st March 2014, the mining operations in the Thakurani block were stopped for want of subsisting environmental clearance beyond 31st March 2014. Let's see this report.
Just a minute. So this is the fact which has been taken note of by the Supreme Court in case of common cause. No.
No, Lord, this is post that order. I'm coming, Milord, I'm coming. That has been.
No. What is the date of that order? What is the date of the order in common cause?
Common cause order has been quoted here, Milord. I'm taking
date of the order.
Below that. That is, Milord, in 2019. I'm coming to that. That is on 12th November 2018, the Supreme Court passed it. Milord, I'm taking that is.
So therefore, paragraph 36 is in tune with what has been referred to in common cause.
Yeah, absolutely correct. So Your Lordship was putting that very pertinent question, which has not been effectively answered. Your Lordship was putting it's illegal mining. He says excess mining. That has been dealt with here. I'm reading one by one. Thereafter,
the Supreme Court had stayed by the mining.
that's correct. So that is not, Milord. Yes, that period cannot be granted. I'm coming to that, Milord. He is asking for that period. This 5 years should be added to the list.
That is his case.
That has been answered by Your Lordship in JDL. I'm coming to that. The same issue. Your Lordship may kindly see this. Thereafter, on 25th April 2014, the Central Empowered Committee constituted by the Supreme Court of India pursuant to the directions in Common Cause versus Union of India submitted an interim report categorizing mines into different layers based on whether the mines possess the requisite usage. SMPL, the present petitioner. Mining lease was placed at serial number 9, list R2, which is comprised of 102 mining leases that did not have statutory clearances. The CC, by a letter dated 10 July 2014, served the response of the state government inter alia as to why the renewal of the subject of mining lease was granted by the state government after a gap of 35 years, which was not in conformity with the MMDR or the MC rules. On 20th July 2014, the state government submitted its response to the CC, setting out the history of litigation from 1963 to 1998, and stated that the renewal had been granted in terms of the orders of dispute and the Supreme Court. The CC filed its final report dated 16th October 2014, stating that the SMPL had worked the mine as per EC granted on 29th October 2008
for 15 MTPA, but the said EC never became operational since the corresponding forest clearance was not granted. It was pointed out that no mining activity had been carried on between 64 to 2001. According to the CC, the first renewal for the mine in question should have been from 1964 to 84. That is 20 years, first renewal, second renewal, and thereafter from 84 to 94. Thereafter, going to the non-renewal of the EC dated 29th October 2008 and closure of mining operation, SMPL addressed a letter dated 3rd November 2014 to the Ministry of Environment and Forest and CC, Government of India, to allow them to work on the basis of the EC dated 22nd September 2004 as an interim arrangement, pointing out that it was co-terminus with the lease period, which says that it was for up to 24. This said request was accepted by the letter dated 15 January 2015. However, it was made subject to the review based on the decision of the Supreme Court on ownership related issues. On 12 January 2015, the amendment, this is important, made to the MMDR Act by the Amendment 2015 came into force. For the purpose of the present petition, the relevant provisions are Section 8 and 8A of the MMDR Act as amended, which read as under. This provision I will rely upon, that has been quoted. If your lordship, I can read from this judgment, that has been the provisions, period for which mining leases may be granted or renewed. The provisions of this section shall apply to minerals specified in Part A of the first schedule. The maximum period for which a mining lease may be granted shall not exceed 30 years, provided that one so 8 AML. Period of grant of a mining lease for minerals other than coal, lignite, and atomic minerals. The provisions of this section shall apply to minerals other than those specified in Part A and Part B of the first schedule on and from the date of commencement of the mines minerals, so and so Act, Amendment Act 2015. All mining leases shall be granted for a period of 50 years. All mining leases granted before the commencement of the Mines Mineral Development and Regulation Act 2015 shall be deemed to have been granted for a period of 50 years. On expiry of the lease period, the lease shall be put up for action as per the procedure specified in this Act. But notwithstanding anything contained in subsection 2 and 3 and subsection 4, the period of lease granted before the date of commencement of the Mines Minerals Amendment Act, where mineral is used for, we are not concerned, extended 6 is very important, which has been dealt with. Notwithstanding anything contained in subsections 2, 3, and 4, the period of lease granted before the date of commencement of the Mines Mineral Amendment Act 1 so, where mineral is used for other than captive purpose, shall be extended up to a period ending on 31/3/2020, with effect from the date of expiry of the period of renewal last made, or till the completion of renewal period. This is important, if any, or a period of 50 years from the date of grant of such lease, whichever is later, subject to the conditions one so. Here, admittedly, that has expired since August 2021. That is not in dispute. The period, it is for more than 60 years, not 50 years even, because the renewal was, as per the last agreement executed in 2001, it was for a period of 20 years. So, your lordship may kindly look to the next paragraphs. That is very 42. On 8th May, the state government issued a letter to SMPL, calling upon it to so cause as to find the period of...
This relates to same mining.
Same mining, Millard. And your lordship may kindly look at the finding also, very interesting. Millard, that was rejected. This prayer has been rejected. I am coming to that part. The aforementioned letter was challenged by the SMPL. So, series of litigation, Millard, your lordship may kindly come to the Supreme Court orders in common cause. Meanwhile, the same mine area, Millard, otherwise, and the same area, Thakurani. The Supreme Court passed a judgment in common cause in 2nd August 2017. It was noted that as far as SMPL was concerned, it had not agreed to the CC's calculations regarding excess mining, as stated in its report dated 16th October 2014. It was directed, therefore, that this issue would be heard independently. Subsequently, on 12th November 2018, the Supreme Court passed a judgment in IA number so-and-so, in this petition, that is the common cause case, Millard.
the Supreme Court directed the CC to rework the compensation payable by SMPL for excess production, taking first year of production as financial year 2004-5. It was held that the entire extraction of iron ore at mines must be considered for calculation of excess production. The relevant observation of the Supreme Court in this regard are as under. We leave it to the central minutes since they were not concerned. That your worship may then kindly 46 may be relevant. Not so many your worship may come to 49. The next page. Let's say the same thing has been written.
Yes.
Let para 48 may I read, Mira? That is also dealt with the undertaking, etc.
Yes, yes.
In the light of the above CC report, SMPL filed IA numbers one showing in WP's numbers in the Supreme Court for resumption of mining operations, subject to submission of appropriate undertaking or any other instruments towards securing payment of penalty for alleged excess production of minerals. In the said IA, an order was passed by the Supreme Court on 15 January 2020 directing as under. In view of the above, the application is allowed in the following terms. SMPL is granted 1 month's time to deposit the dues assessed by the CED, that would be CC, in its report dated 8/5/2018. In addition, SMPL shall find an undertaking to comply with all the rules, regulations, and other mandatory provisions for carrying out mining operations. This is important. 886 mines. After complying with directions 1 to above, SMPL can resume its mining operations in the leased area for the remainder of its lease period. That was up to August 2021. Remainder doesn't mean another 5 years would be added. That has been answered. The same point, the way my learned friend Mr. Jain is arguing that because of the government's inaction, that period should be compensated applying force measure 12(1) FF. That has been dealt with. I'll answer that. I'm coming to.
No, but whether that agreement of 2004 has been dealt with. You are relying on 2004 agreement, Mr.
Yes, that has been dealt with. 2001. 2001.
The agreement is of.
Yes, I'm coming to that. That has been dealt with.
No,
in no case it would be beyond August 2021. That is the finding here.
That is the finding.
Yes, I'm taking your last.
Just one more.
Yes. That para 55, 56, 57 deals with the 3 writ petitions, prayers of the 3 writ petitions, which were taken off together. That you will achieve. I'm not taking you lordship. This say he was praying 56 million. Meanwhile, on 25th January, WPC number 3115 of 2021, after this resumption order, was filed by SMPL for a direction to the state of Orissa to execute a lease deed for the remaining period of 10 years out of the 30 years renewal that the SMPL claims entitlement in terms of the orders dated so 91 in OGC number 94, so many writ petitions passed by the state government. Notice in this said writ petition was issued on so by order dated the other 2 writ petitions. Your lordship may kindly now come to yes, the by order dated 20th May, you're right. The state disposed of the so-called proceedings in terms of this court's order dated 6th August 2019 in WPC number 15 by holding that the validity of the lease would expire on 13th August 21 and further action will be taken for auctioning of the mining lease after the expiry of the said mining lease period. The aforementioned order dated 20th May 2021 was challenged by SMPL and its director in WPC number 17905 of 2021, which has been dismissed after with a detailed order. A order dated 7 June 2021. This court on 7 June 2021 allowed I numbers 1 so seeking to amend WPS 1 so seeking stay of the aforementioned letters, this court passed the following interlocutory order. Millard, your lordship may now kindly come to then followed by contempt. These submissions have been dealt with by Mr. my learned friend, Mr. Jain and senior counsel, Mr. Sibal. They were representing the same party. Millard, the exhaustive submissions which cover most of the submissions now advanced. Your lordship may now come to Millard.
Yes.
66. Analysis and results. The above submissions have been considered. That all those the same thing essentially. At the outset, it requests to be noticed that the changes brought about to the MMDR Act by the MMDR Amendment 2015 introduced a new regime in the context of mining leases in the country. The SOR of the MMDR Act, Statement of Objection, so and so, acknowledged that the mining sector had been subjected to numerous litigations in the earlier 3 years, and many important judgments had been pronounced by the Supreme Court of India. Besides the judgments on the issue of allocation of natural resources, which had a direct relevance to the grant of mineral concessions, the Statement of Objection reasons proceeded to note as under. The present Millard, I need not edit Millard, you will see, to further explain the scope of this MMDR amendment. Let us go to Millard part. The starting point for the present litigation is the lease deed itself executed on 14th August 2001. That is annexure 6 to the writ petition for a period of 20 years. Whatever may have happened prior thereto, including the orders of this court and the compromise decree and the rights of the parties, got crystallized only in the said lease deed dated 14th August 2001. If one carefully peruses that document, that is annexure 6 here. Document, it is seen that it is between the state government on one hand and SL Sarda and Sri ML Sarda on the other. Under Rule 39 of the MC Rules 1960, the document is itself titled Renewal of Mining Lease, and the period is clearly specified as 14/8/2001 to 13/8/2021. This is important. From 14/8/2001 to 13/8/2021. This document doesn't have preamble clauses. It makes no reference to the compromise decree or anything stated thereunder. It clearly states that the term 20 years is next ensuing. As far as the rights of the renewal are concerned, clause 3 of part 8 of form K, that is the agreement which is under the title Covenant of the State Government states that the mining lease is renewable in terms of the provisions of the Act and the rules made thereon. It is plain, therefore, that the right of renewal would be subject to the provisions of the MMDR Act and the MC Rules 1960 in force at the stage of renewal. In other words, there was no promise held out in the said list of any renewal, irrespective of the statutory provisions. In fact, given the settled legal position, there could possibly not have been any such promise held out. Thus, on plain reading of the list dated 14th August 2001, there is nothing in it which holds out an assurance to the leases that notwithstanding the provisions of MMDR Act and the MC rules, renewal would take place in terms of the orders passed by this court on 28 June 1991 and 18 December 91, or the compromise decree, etc., etc. Even from the letter dated 13 July 2001 of the state government, it is clear that a second renewal of the mining lease has been granted for the period of 20 years. There is no doubt that the entire exercise has been done in terms of MMDR Act and the MC Rules 1960. That the mining lease in Form K makes this position abundantly clear. There is merit in the contention of the state that by accepting the aforementioned listed in Form K, Sri M.L. Sarda and Sri S.L. Sarda should be taken to have by their conduct waived their rights to seek the further renewal for another 10 years. In this context, the following observations in United Spirits and so will have different case laws. Then your lordship may kindly come to 76 million. In Common Cause versus Union of India, the Supreme Court had occasion to interpret Section 8A as inserted by the 2015 amendment, which came into effect from 12 January 2015. The dispute between the parties before court was crystallized in Para 23 as under. There is a serious dispute between the rival parties with reference to the interpretation of Sections 8A3, 8A5 and 8A6 of the MMDR Act. Whilst the contention of the Law Council appearing for the petitioner common cause is that the benefit of subsection 3, 5 and 6 of section 8A will extend only to such mining leases as were subsisting on the date of introduction of the amendment. It is the contention of Law Council representing the leaseholders that the above postulation at the hands of the Law Council for the non-applicants is wholly misconceived and would result in sponsorship. Having analyzed the SOR of the bill, the Supreme Court explained as under. From a perusal of the extract reproduced above, 21 that I claimed. Yeshua, from the perusal of the extract reproduced above, it is apparent that the insertion of Section 8A into the MMDR Act was to address the hardship faced by the leaseholders, besides other reasons due to the second and subsequent applications for renewal, remaining unattended at the hands of the state government. The instant amendment to the MMDR Act introduced a uniform original grant period of 50 years or for all mining leaseholders. It also excluded renewals after the expiry of the original lease period. Accordingly, no renewal application can now be filed. So and so, in our view, such leaseholders who had moved up, this may not be that relevant. They have explained here. Your Lordship may kindly turn to Para 79. That is the conclusion. In view of the amendment to Section 8A of the MMDR Act, read with its interpretation as above by the Supreme Court of India, this court is not persuaded by the argument of learned senior counsel for the petitioner that a deliberate attempt has been made by the state government to misinterpret Section 8A6 of the MMDR Act. The expression till the completion of the renewal period, if any, cannot be interpreted in this case as renewal up to 13th August 2031 in the absence of an express clause in the lease deed that permits such renewal adheres the statutory provisions. The period of renewal cannot extend beyond 13th August 2021. The expression till the completion of the renewal period occurring in Section 8A6 of the MMDR Act can only be 13th August 2021. Section 8A6, that is the period on which his lease has already expired. But it should have been put to auction regime now. For 3 years, the state has been losing the revenue because he has been occupying that area. 3 years, more than 3 years. So, Section 8 revenue has been lost to the state.
This writ petition was filed in 2024. According to you, in view of this court's decision, that decision was rendered in 2022.
It's gone to Supreme Court against that. That is pending for 10 years. The sixth extension for this particular case belongs in civil appeal number, the SLP number.
That we have seen. That matter is pending.
Yes, pending in Supreme Court. They are here. How many? I was confused. Not less than 30 petitions. I was searching from the website today. 30 by the same petitioner at on various points.
Oh, so,
some other. Yes.
So that writ petition was praying for extension of 10 years on another ground. This is extension of 5 years.
This is not extension. Therefore,
I'm coming to that.
Mr. Acharya, he has been very careful while making his submission. that this is not for extension.
Not
This
careful,
is-
my lord. His price think that everybody should be doing. At some point of time, someone has to be cut.
We should not, we
Yes.
should not, we should not make
Prayer,
this comment.
which has been directly, my lord, denied by your lordship or declined in the earlier writ petition, that it can't be a date beyond 13th August 2021. He now very carefully votes this writ petition without making any challenge to any of the orders of the government that this period should be added. Exactly the same, my lord, I am coming, I am answering. Your lordship may kindly look at the prayer in the writ petition and also the cost item. That is very interesting.
In terms of the amended act.
Amended act is
Making
fairly
prayer in terms
applicable.
of the
my lord.
existing
Yes, amended act, my lord, is applicable. It can be beyond. my
Mr.
lord.
Acharya, therefore we had put this question. That when they resumed the mining operation in 2020, why did they not approach
Right.
for adding up that period
Period.
soon thereafter? Why in 2024? This is one aspect.
Right.
The other aspect is that they were pursuing the matter
Right.
for extension of 10 years.
That's
Extension for 10 years.
10 years.
That was rejected
Right.
by this court in 2022. They went to Supreme Court.
Right.
The matter is pending in Supreme Court.
Right.
There is yet another aspect. See, the plea which they are raising, that if not 10 years, at least this should have been given.
So that prayer could have been made in 22 or in 21.
This is
also.
what-
There
this
is
is
no
what-
whisper in the
This is
earlier
what,
petition.
this is what,
It's a-
this is what we are saying, that if some plea was available to them,
Right.
and if they failed
Failed.
or decided not to
That's
raise,
correct.
what is the consequence of that?
That's correct. Dr. Minor
This is-
Justice Rath was also putting that very same question. 14 is the issue. Supreme Court put a stay on that. You can't because of the SA Commission and illegal mining, everything.
No,
So
I was
they
wondering that
ultimately.
now it is clear because he also said that we were busy with litigation, so this is the litigation.
This is another round. This very same question has also been dealt with in JDL mines. They very direct the same point I
All
was.
right.
That is also due to statutory clearance.
That-
The state government did not. JDL mines. That judgment I have given in the counter. Or equal
That
that is.
force majeure and.
Yes, that everything has been. I was arguing also force
He was
majeure.
the other side.
Yes.
People are doing that.
I was in the other
In fact, that was the first, I think, first argument which you had made.
Lordship is absolutely correct. That was my first argument before your lordship, after this one, after the hearing. And the argument, my lord, which I am going to advance, that was advanced by these states.
Yes,
And the
in
same
different
argument
capacity.
I was advancing like Mr. Jain, that
Yes.
it should come within the force pressure. JDL mines.
Okay.
Lord, that is the, Lord, that judgment is, my lord, at page 59. Your lordship said. Lord, two other judgments of, my lord, Justice, this honorable court, my lord, Chief Justice Javeri, and my lord, that Santi Priya of Justice
That has been
Moka,
taken
judgment
note
of
of.
Karnataka High. Lord, that has also been referred to here.
Yes.
59. Is 59.
Page 59 of what?
Page 59 of the counter affidavit. I have given these three
Of the
judgments, my
counter.
lord, in the counter affidavit. RP Sao, JDL Mines, and Santi Priya.
Yes.
Which I had placed. Which I read.
But the same ground, same point, everything. Whatever is being raised here, the same issue. May I read the factual matrix?
Is not required.
We mining pillar para page pillar 59 of the counter.
Yes, clause 4 was dealt with.
Yes. Remember this factual matrix, if your lordship would permit me, manifestly invoking the provision. Before that, the history of this grant of lease, everything. Petitioner number 2 is this so and so, including the insertion of subsection 3 thereof contemplates that so and so, will be deemed for 50 years. Manifestly,
Invoking the provision under subsection 3 of section 8A, the validity period of the original lease dated 21 to 74 has been extended in the case of the lessee to 22/2024 by a supplementary deed executed on 30/3/2016. Petitioner number 2, who is the legal heir of late Ram Avatar Jalan, had approached this court by filing the present writ petition, primarily seeking a direction that he should be allowed to conduct mining operations based on the original lease deed dated so and so, read with section 8A3 of the MMDR Act for an additional period equivalent to the period 9/1/2012 to 5/11/2015, for which the petitioner would not conduct the mining operations because of the interruptions, disruptions caused by the state authorities, which the lessee would not reasonably prevent or control. The force majeure clause, plus 4 of part A of the lease agreement, read with Rule 12(1)FF of the Minerals Sponsor Rules 2016, with the substratum of the petitioner's claim. At the very same thing, because I had the statutory clearances in that case, the state did not, since 2012, the state did not grant the resumption order, did not pass. After 3 years and 10 months, they passed the resumption order. So I came before your lordship and claimed that since it was not due to my apathy, but because of the inaction of the state authorities, the resumption order could not be passed in time. So that period should be added to the period of 50 years. So, but you will not be fair to the contrary. Lord, we have heard so and so, and the facts in this case are not at all in dispute, which need to be taken note of at the outset. The mining lease in limestone, so and so as noted above, with effect from the original lease under a part of, this is not relevant. The para 6, your lordship have dealt with that. It was obtained. It was not there in 2009. Mining operation was stopped. DDM passed an order to stop mining operation. I got the clearances in 2012, but they did not grant the resumption order. So that is dealt with in para 6 and 7. Recommended to the director.
Mr. Acharya, you will have to forget that the case was argued by you.
That's
so you are repeatedly saying this, that my and the government. So you are in different capacity now.
Different capacity. No,
yes, please.
I'm
sorry.
I'm sorry.
Yes, no, Mr. Sir. Just on a lighter note. Yes.
Rejecting the clearances, Millard, your lordship may kindly. Another date was fixed for personal. Millard, para 7. The Deputy Director of Mines recommended to the Director of Mines for the resumption of the mining operation. The Additional Secretary to the Government of Odisha was apprised of the compliance of statutory clearances regarding the mining lease area by the Director of Mines with a recommendation for resumption of the mining operations. On 16/5/2012, the lessee was asked to appear for a personal hearing by the Additional Secretary on such and such. Another date was fixed for a personal hearing. In the meanwhile, the lessee filed a division application before the central government, challenging the order dated so and so, filed by the of the Director of Mines, rejecting the mining dues clearance certificate while so and so, which was registered, and the division application was disposed of with direction to the government to allow resumption of the mining operations till expiry of the current lease period, 20 years from 2294. The regional authority in its order mentioned the state government might take appropriate measures for recovery of all legally recoverable dues from the petitioners. In the background of the submissions and the counter submissions which have been advanced on behalf of the parties, it is deemed to reproduce the relevant portion of the said order. Milord, it is not necessary, Milord. Your lordship may kindly come to.
Yes.
I am not reading the whole thing. from para 22 minutes, your lordship have dealt with it.
Yes.
It was in this background, Mines and Minerals Amendment Act was promulgated on so and so. On one of the salient features of so and so as mentioned in the statement of was for the removal of discretion in the procedure. That has been quoted the statement of objects. Referring to the statement of objects and reasons, the Karnataka High Court in Santipriya has held that one of the basic objects of Act 10 was to make auction as the only mode of grant of mining concession, as the existing provisions of did not permit auctioning of mineral concessions. Another object was to eliminate discretion and improve transparency in the allocation of mineral resources. Another salient feature was removal of discretion and introduction of auction to be the sole method of allotment of mineral concession. By the amendment, the tenure of mining lease was extended from 30 years to 50 years. We respectfully concur with the view taken by the division bench of the Karnataka High Court while referring to the basic object of Act 10 of 15. After having observed so, the Karnataka High Court in Santipriya has viewed that by virtue of subsection 4 of section 8A, where extension of mining lease is granted under any of the provisions of section 8A, on expiry of the extended lease period, the lease had to be put up for auction, and extension beyond the period provided in subsection 6 of section 8A of the Act cannot be granted. We are in respectful agreement with the said view also of the Karnataka High Court in the case of Santipriya Minerals. The division bench of this court in the case of Ramesh Prasad Sao had the occasion to deal with the similar circumstance where the petitioner of that case claimed restoration of the lost period, relying with the same issue RP Sao. That also was carried to Appeals Court, relying on clause 4 of Form K, Part 9 of Mineral Concession Rules, the force majeure clause on the similar ground that interruption, disruption were caused for a considerable period of 10 months and 20 days, mainly on account of the act or omission on the part of the authorities of the state government and pendency of the various legal proceedings before this court and the Honorable Supreme Court in respect of mines in question in that case. This court, after having referred to the decisions in the case of Begraj Singh and Dharambi, concluded in para 30.1, which reads as under. In view of MMDR Amendment Act 2015, and more particularly, there is no extension on record after 2013, and the petitioner having accepted the supplementary lease deed of 2015 up to 31st March 2020, in our considered opinion, it would not be appropriate to extend the lease period or grant the petitioner 45 months and 9 days, contrary to section 8A6 of the MMDR Act, having accepted the supplementary lease without any demur in 2015, the petitioner cannot possibly raise any objection for the period prior to execution of the said lease. We find substance in the submission made by Mr. Parija, Lord and AG, that the present case is well covered by the coordinate bench of this honorable court in the case of Ramesh Prasad Sao. We see no reason, based on the submissions advanced on behalf of the petitioners, to take a different view than what was taken by this court in the case of Ramesh Prasad Sao. It would be pertinent at this juncture to notice that admittedly, the supplementary lease deed was executed so and so. Under an order passed by the Director of Mines, the lease was allowed to resume the mining operation from 5/11/2015. The original lessee, without any demur, accepted the terms of the lease deed without not only mentioning the date up to which the validity period of the lease was being extended, but it contains specific reasons why such extension was being granted up to 22/24 with reference to 8 AM. That may not be relevant, but the whole essence is that there can't be any extension beyond Millard 8A6. So that is the purport. And the same thing has also been dealt with in the earlier judgment of Chief Justice Muralidhar, Dr. Muralidhar, which I read out, that it can't be a date beyond 13th of August 2021. So that those points are no more res integra. I don't think that anything would suffice because the facts are not in dispute, that the lease period has already expired since 13th of August 2021. The amending provision of section 8A6, Millard, is a overriding provision, non-obstinacy clause that overrides everything, Millard, whether it's under any agreement or compromise deed or anything. So whatever may be the reason, and first of all, Millard, it was due to
an order, prohibitory order of the Honorable Supreme Court. And he didn't have the statutory clearance. After it was obtained, when he applied to the Honorable Supreme Court, they could have made this prayer before the Honorable Supreme Court that this for this period we were prevented from operating, so we should be given. The Honorable Supreme Court
No,
said
that was different thing.
that was
That-
therefore, Milord,
That
the-
is possibly individual cases could not have been considered.
that's correct. So therefore, Milord, the claim which he is making now, that plea, Milord, was available to be taken also in 2021. He came before your lordship in the earlier round of writ petition. He claimed for a period of 10 years extension to be added beyond 38/21. So that was also, Milord, not granted by this Honorable Court. Now the prayer on which his Milord claims that because of the state's inaction or non-operation of the lease. So I should be, this period should be added to the lease period beyond 21 is not permissible, Milord, in view of the amendment of 2015. So the same thing, Milord, all those I need not elaborate,
Not-
or the burden your
Yes.
lordship with the
Yes.
same judgments.
Yes.
As we saw the same ratio and
Yes.
this Santipriya also the same thing. Provisions are very clear. I need not, Milord, take your lordship. This, if you lordship, I may
Thank you.
file a short written note. If
You
your
please
lordship
do
would
it.
require me with Milord reference to the judgments and the date chart, everything, and the sequence of events. I was preparing, I thought that, Milord, fortunately
Please.
that matter got adjourned. So therefore, I don't
All
have
right. All right.
that, I don't
Yes.
think anything would suffice.
Yes.
Yes, sir. I'll just be very brief, not in bullets. Point one, my learned friend started with a grand attack that now.
No, the learned judge made an observation.
Sorry?
One of the learned judges also in the observation that why didn't you raise the point, they raise this issue? You were fighting litigation before this court.
I'm going to show that.
That could have been an alternative.
Correct. So let me first, my learned friend started with this aside. It should be dismissed on the ground that you have not disclosed it. Page 19 of my writ petition, your lordship may just take it in the interest of time. Para 10 expressly mentions this writ petition 3115 of 2021 and that issue is pending in the Supreme Court. So let me first get one thing step by step out of the way. One second. Second, I'll just do it in bullet. If you want me to see something, I'll do it. But for the moment, I'll just take it. Your lordship may take it. Page 19, para 10 expressly mentions 3115 of 2021. Point 1. Point 2, 3115 of 2021, my lord, the actual writ petition in para 17, as my lord rightly put to me, expressly reserves this right to file proceedings on this aspect. That is 5 years and 10 months in para. My lord, at page 18 of the writ petition, para 32.
Paragraph?
Para 32. 17BB. At page 17 and 18 of that writ petition.
The earlier writ petition.
Yes. Expressly reserves the right. 1 second, I'll just.
Yes.
Now, my lord, your lordships, because my ladyship had mentioned that some other, we filed a detailed affidavit on 14/11/24 pursuant to my lord's order of 5/11/24. My lord, kindly have page 5 of that affidavit.
Yes.
It shows how the two issues are completely different. So it's, I'm sorry, I may not have a running page. It's filed on 14/11/2024. Sorry, flag D. My lord, I believe it's flag D.
Yes, it is there.
My lord, kindly have page 5. My lord has page 5. My lord, it says difference between present writ petition and civil appeal. Present writ petition is seeking 5 years, 10 months lost in the period 1/4/14 and 31/1/2020 within the time period of the 20 years. Right, my lord? Please see the other civil appeal. Petitioners are seeking direction to the opposite party to execute a mining lease for the remaining period of 10 years under a grant order of 11 February 1999 in view of this court's order of 1991 and a compromise decree dated 30th June 1998 that have attained finality. Now, my lord, proof of the pudding is in my lord's judgment, which my learned friend mentioned at page 56, para 83.
Yes.
It says, I'll just read in the interest of time.
Paragraph?
My lord, para 83. It says, this court rejects my petition for renewal of the mining lease beyond 13th August 2021. That case is an entirely different case. And my lord, the Supreme Court on 2/12/2021 and 4/2/2022 not only has issued notice but given status quo and made that order absolute as well. So this issue is pending in the Supreme Court. It has nothing to do with the subject matter here. And if my lord sees the powerful battery on the side of the respondent there in the second order, it will show the force put and the order of the court as well. First is 4th February 2022, and please now have 2/12/2022, the next order. Leave granted, interim order made absolute. And my lords have settled it. When leave is granted, the impugned order is in jeopardy. Exact language used by the Supreme Court. Leave granted, interim order made absolute. So that doesn't come to his aid at all. Apart from the express reservation of my right to pursue this very issue in that writ petition, the prayers are entirely different, based on a grant order and a compromise deed. And my lord, please take it from me.
No. So what happened in that case?
Which case?
That matter is pending.
It's pending. Leave granted. Please see the second order.
You wind up your argument. So arguments have been,
Nothing is happening.
nothing has happened.
Leave granted. The position stays as of whatever was the position in this order. That's it.
Position on 2/12/2022.
Yes. It's pending. Subject to correction by the other side. It's leave granted with this order. So, my lord, all that my learned friend said, and I was a little prescient when I started. I said, you will hear everything which will take the vote in a different direction. So I anticipated this, and therefore I'm pointing out to you. So, full disclosure, affidavit filed pursuant to my Lord's Order 511. Difference set out. Para 83 says that is renewal. That is not the case. But short point, leave granted, status quo. So that doesn't come to my learned friend aid at all. That with greatest of respect was the only thing my learned friend argued. He didn't address any of the other points which I raised. So I take it that's all he had to say. I only have to meet this. The two judgments he relied on, my lord, fell for my lord. Supplementary deed where you acquiesced. So that is entirely different. Whatever capacity my learned friend appeared. But facts are there was an acquiescence by virtue of a supplementary deed. In my case, I've agitated it continuously. So, my lord, there is no impediment apropos the contentions raised now by my learned friend, which is only based on this one thing. You are trying to have a second innings issue decided by this court. That's entirely wrong. And that affidavit that I filed expressly, my lord, deals with it in detail. I only read out one in the interest of time. My lord, my respectful submission is allow the rest.
All right, we'll try. Judgment reserved.
Not on a lighter note, the baton has passed. We have done whatever we could on this side.
Very difficult, Mr.
No, I fully appreciate.
You, every one of you must appreciate.
But I fully
the kind of.
I'm deeply grateful as well.
That basically anytime also change.
But we need a status quo on that.
Yes, Mr. Mohanty is waiting for a.
Yes, we're. Would your lordship like any closing submissions or?
Please do it. That will help us, and you also, Mr. We are closing it.
File written note of service.
We can close it, Mr.
Yes, we are done.
See, we are of the prima facie view, Mr. Acharya. After having seen the division bench decision, we had formed an opinion that at least that observation is final and we cannot go beyond that. This is one aspect. The other opinion we tentatively formed is that in view of the Supreme Court's observation, probably whether, this is for Mr. Jain,
Please.
whether we can go beyond that. If the Supreme Court, whether if we allow the relief which he is seeking, whether that will amount to altering the observation made by the Supreme Court in the case of common cause, even if we are satisfied on the question of law. Are we clear, Mr. Acharya?
I'm clear, Miller. Remainder mean, it doesn't mean that the.
Whatever.
The Supreme Court says that the period means whatever the lease.
Whatever,
period.
whether the question is any observation.
So that means
made by-
clarification, if at all, that can be given. by the
Exactly.
apex court,
This is what.
Not by.
This is what is there in our mind. This is what we are thinking. We are just expressing our opinion. Even if we agree with all the submissions which have been advanced by Mr. Jain, it will be difficult for us to make any observation which may run contrary to or which may dilute the observation made by the Supreme Court in paragraph which he was referring to. We cannot clarify.
That's correct.
We cannot clarify it. This is just our. We don't know what are we going to decide.
Remainder
These are-
doesn't
these are-
at all mean
these are-
that it would circumvent.
Remainder, even without remainder. This is our tentative view. We don't know based
In
on.
the very same common cause case, they have also interpreted the scope of 86. That the whole.
We will see, Mr. Acharya. That will depend on, you have made your submissions, Mr. Jain will be submitting his notes. You please also do it. We shall also try to deliver based on,
On a lighter note, there's no add back to 19/1/2025.
But I'll file a written note of submission. It may grant some time.
We are only seeking up to 19/1/2025.
But I would file a written note. Your lordship may grant me a waiver.
whenever, do it as soon as it is possible. Otherwise,
You never know.
Exactly. That's in the court's hands. Not on this, can I just take only one? Right. We'll of course address this expressly in the manner that my lord has indicated. But I just want to make one point to satisfy the conscience of the court, which is this. Let's take the Supreme Court judgment as it is. So the line is, that for the remainder period of the lease, that is in the context of extension stroke renewal.
we will see.
No, I just half a second. I've therefore started and I end with the same thing. The issue has to be seen in context. The issue here is add back in the context of a wrongful order of suspension coming in the way. That is not the issue there, and my lords in the Supreme Court, they have to see an order.
We are not very
Supreme
much.
Court doesn't
See,
say it's a wrong order.
No.
Supreme Court doesn't say it's a wrong order.
I never said wrong order.
Mr. Acharya, we are Mr. Acharya and Mr. Jain, we are not. Mr. Acharya, Mr. Acharya, we also have a right to be heard, We are not on that expression for the remainder period. But the suspension order was also by virtue of the Supreme Court's
That's correct.
order. So therefore, whether we are just thinking, it is. I'm reiterating Mr. Jain and Mr. Acharya that whatever observation,
CC report.
whatever observation we are.
Let's see, I will file. Not how the whole CC report, Milord, I will file in my written note of submission. They have been indicted like anything that this is only one in the country, Milord.
Mr. Acharya, we will see.
Can I just hand over? This is very important. 16th May, what my lord said. Please see the order. The order itself.
Order of?
The Supreme Court order, which my lords are
Common cause.
Interim order. Yes. Please have para 4. This is the actual order. Not 16th May 2014 was the interim order. Please
give us.
Yes, I'm only adding one line, para 4. It expressly says because of the CC report, Supreme Court has not held in an interim order that you, Mr. Petitioner, have violated X. Says we have considered the report of the COC and we find that 102. Can I just complete?
We will see.
Can
So
Supreme
I'm
Court
saying, my lord,
and direct for payment of a penalty of 900 crore Because when they were.
Can I just finish?
Innocent cannot be.
I'm only pointing out, I'm not adding. Supreme Court acts on the CC report.
We
and
have
asking that-
a meeting
Yes, sorry.
with the CJ.
Sorry, madam.
Yes,
When
Mr.
CC is appointed with.
You please give us whatever you
Yes,
want
we
to
do.
give. We cannot go beyond the pleadings of the court. And the submissions, yes, we can find out, but we cannot go beyond pleading. Yes, yes, we will take up. No, we will take. We will take up just a minute.
We're very deeply grateful.
Please call us.
Lord, they have handed over us a copy of the mining plan yesterday. From that, you affirm that they are granting a lease, proposed to grant lease for a period of 5 years. My project is for.
Yes, Mr. Could you get the instructions?
Yes, Lord, I would.
Mr. Acharya, wait for a minute because of the importance of the case also.
After instruction, not simply keep it to some other day. I will.
We will take up on.
Yes.
Monday.
That is all right, Lord.
Mining plan has been approved.
Lordship's leave. We are immediately on the set of this.
On
we
that
have
one, I have
filed an application there also.
Do it.
I will make available a copy of that application to Mr. Panda and I will
Yes,
put
yes.
this in affidavit tomorrow. Let this matter come up.
Mr.
on Monday.
Acharya, the only question is that mining lease was granted.
Worried.
Granted for construction of national highways. So it is connected with construction of national highway. Construction of national highway has been obstructed because of some environmental clearance, forest clearance.
For that material, then they withdrew that.
That has been withdrawn. So therefore, the construction has stopped. Therefore, the intervention is required. So please.
Monday. Let it come on Monday.
It will come on Monday. So it's in public interest that
That is
we
so
should.
it is public interest.
Yes, it is in public interest, though it is in his,
I got
though it is in his interest also. But public interest is also involved.
National highway may be.
Yes.
Execution contractor.
We will take up the matter on Monday. Mr.
Well, I will make available my bone of contention to Mr. Panda tomorrow.
That we understand that he'll, now learned Advocate General is also here.
Did and fifth lordship very technical. There is no technical bit. Had it been order lordship for any
Not now, the meeting.
lordship, only for Monday lordship.
All right.
What can maybe?
44 Monday, my lord. That is Elias to play of better man.
All right.
Monday.
All right. We will.
And they wanted time to file counter.
Otherwise, there is definitely construction is going on.
interim order.
Which matter?
44, item 44.
Is this PIL?
PI one.
We will discuss it right now.
Elias to students playground. I mean,